Guten Morgen an alle.
Вітаю всіх, шановні колеги.
Шановна пані Данишевська, доброго ранку.
Вітаю, пане Норкус.
Добрий ранок, Валентина Іванівна. Добрий ранок, Михайло Іванович. Через 2 хвилини ми починаємо. Прошу, будь ласка, учасників, гостей,
Participants will be starting in 2 minutes, so please join us. Please get ready and organize so that we could be getting on our way very, very soon. Thank you, everyone.
Добрий ранок, шановні учасники нашого.
So, good day to everyone, to the participants of our workshop today, which is titled The Application of the Constitution as an Act of Direct Effect in Administrative Proceedings. This is the second meeting we are having. We had a similar meeting last year when we discussed a matter just as relevant that we will mention today. And we wanted to ensure that there is a certain continuity of our meetings and a certain logic of our meeting. So I'd like to give the floor for the welcoming address to Valentina Danishevska, the President of the Supreme Court. Thank you for giving me the floor, dear colleagues, dear judges, your honors, esteemed guests. It's a pleasure for me to welcome you, if virtually, but from the Supreme Court. And this is the second event we are conducting dedicated to the exercise of the powers of the General Court and the Constitutional Court. I'm sincerely grateful to the judges, in particular to the President of the Constitutional Administrative Court, Mr. Smakovich, and Miroslava for having come up with the initiative to organize these events, as they're very important to raise the standing of both the Supreme Court and the Constitutional Court, and overall for the establishment of the rule of law. Initially, I'd like to welcome and thank our partners of the Supreme Court, and of this event in particular, we've been supported by the Council of Europe project of the OSCE, the German Fund for International Legal Cooperation, and all those that I see on the screens and others are very much welcome, and we're thankful to you for standing with us. I also have the greatest pleasure of welcoming our guest, Dr. Lars Brocker, the President of the Constitutional Chamber of the Supreme Court of Rhineland-Pfalz land. Rinvidas Norkus, I'm very happy to welcome Rinvidas, very happy to see you. He's the professor at the Nicholas Romeris University and judge of the General Court of the European Union. I'm happy to welcome George Papuashvili, a former president of the Constitutional Court of Georgia, former Minister of Justice of Georgia, professor, expert, former member of the European Commission for Democracy Through Law. Also, with us, I hope we have Slavica Banic, who is the judge of the Constitutional Court of Slovakia, former deputy director of the European Commission for Democracy Through Law, and the expert for the Council of Europe project. We also have Hanna Kristova with us, and she will also make a presentation. She leads the project of the Council of Europe called Internal Displacement in Ukraine, Building Solutions. And I have the pleasure of welcoming our colleagues from the Constitutional Court, Viktor Horodovenko and Vasil Lemak. Even though we are located next door, but we don't have many occasions to meet as often as we would very much like to, and we're grateful to Miroslava Bigelik for convening us together here so that we could talk and discuss and shed light on these matters. The powers of the Supreme Court and General Jurisdiction Courts and the powers of the Constitutional Court are different. However, as the courts operate, both the Constitutional Courts and the General Jurisdiction Courts have to interpret the Constitution. And if they do not apply their powers with great scrutiny, we might end up in a predicament when the findings of the Constitutional Court and the findings of the Supreme Court as to the interpretation of the Constitution and the law being unconstitutional might vary. This surely is not going to boost the standing of the Supreme Court nor of the Constitutional Court, and that would be a shame for the society. So, to prevent this from happening, so that both the Constitutional Court and the Supreme Court could act consistently and stabilize their case law, we need to meet as we meet today. I personally have a few recipes of how we can avoid such controversies. Before everything, I would believe that the General Jurisdiction Courts and the Supreme Court, as they interpret, they should resort to interpretation of the law so that we would exercise our powers to apply the Constitution instead of applying the law. We should avoid unnecessary efforts. We should not interpret the letter of the law, but rather the spirit of the law, and to prevent discrepancy between the interpretation of the Supreme Court and the Constitutional Court when we do interpret the law. We need to offer the intent, the spirit that will be consistent with the Constitution. And by doing so, we will reduce the number of events when the courts have to apply the Constitution as a direct act instead of interpreting the law. Moreover, the Constitution often deals with close relations, and the courts have broad powers in terms of applying the Convention of Human Rights. So I would say, if the Convention helps address the dispute and adjudicate it without having to resort to Constitution as a direct act, we should do so freely and resolve the dispute fairly, applying the Convention. I am certain that today, around this virtual roundtable, we will hear many more ideas on the ways we could exercise our powers so that the case law, the court decisions, and the regulation of the legal relations would be stable, consistent, clear, and most importantly, the people could feel that there's one law for all. And the complex theoretical introspections should not affect the disposition of the people. I wish us all very interesting presentations, lively discussions, so that together we could serve the law, serve the Constitution, and apply the Convention. Thank you very much for your attention and a very good discussion to everyone. Thank you, Valentina Ivanovna. Thank you for your welcoming address. Thank you for your warm welcome. Now I'd like to give the floor to Mihailo Smakovich, the President of the Administrative Cassation Court of the Supreme Court, for the welcoming address. Mihailo Ivanovich, the floor is yours. Thank you. Good morning to the participants of the international workshop, dear colleagues, dear friends. It's my pleasure to welcome you with the opening of the international workshop on the application of the Constitution as an act of direct effect in administrative proceedings. As Valentina Ivanovna was saying, the Cassation Administrative Court, comprised in the Supreme Court, has organized similar events before. So last year, indeed, we conducted an international workshop dedicated to the legal consequences of deeming a statutory act unconstitutional to uphold the human rights in administrative justice. It's a pleasure to say that these events are milestones and help to propel the development of administrative justice in Ukraine. Owing to such meetings, we have a chance to talk face to face, look into the important facets of administrative proceedings, effectively exchange ideas and share professional practices. The administrative justice of Ukraine, owing to such a discussion, is becoming stronger, better, more experienced, and wiser, therefore. I hope sincerely that today's event of this practical workshop, due to the active contribution of our esteemed participants who have professional insights into both the theory and practice of administrative justice, who know in depth the problems of administrative justice, will be just as productive and as beneficial. So the Cassation Administrative Court, comprised in the Supreme Court, heartily welcomes all the participants of this workshop and grateful to everyone who is joining us today. Let me say that the administrative justice in Ukraine is only 16 years of age. This is a long time, but not that long. When we say it's a long time, we consider all the cases the administrative courts have reviewed. Starting 2005, the administrative courts considered 17,164 cases. In the period since the 1st of September 2005, including November 21, just the cassation level received 856,905 cases, of which 794,000 cases have been disposed, and another 14,000 cases roughly are still pending review. So indeed, we have a very responsible and very painstaking undertaking before us, as the court cases are about people's lives and expectations. When we talk about the 16 years experience of administrative justice in Ukraine, we see it as a teenage. And this is when people are very curious, very passionate, ready to tackle any challenges, be very proactive, sometimes be unprepared to make compromises, but be idealistic. So this workshop will also serve the end of boosting us professional. It's very important for us to cooperate with the national and foreign academics. We are very open to the constructive dialogue, to the subject matter discussions of some relevant and challenging questions about resolving the disputes, where the administrative courts act as an arbiter between the government and the people. So I have the greatest pleasure welcoming everyone yet again to the international workshop, which I hope will share the ideas, opinions, considerations, and suggestions as we discuss the application of the Constitution as an act of direct effect in administrative proceedings. And it's a pleasure to see the highly esteemed participants, our Valentina Danishevska, the President of the Supreme Court, Vsevolod Knязев, the Secretary of the Grand Chamber of the Supreme Court, who's been elected and who is to take up his duties as the President of the Supreme Court. It's a pleasure to have our permanent good friend, Lars Broker, Rimydas Norkus, Georgi Papuashvili, Slavica Banish, our dear friends from the Constitutional Court, Vasil Levok, Vasil Hordvenko, Hanna Christova, and most of all, we always have the German Fund for International Legal Cooperation standing by us. Since 1992, it has been actively supporting Ukraine as it reformed its legislation and organized administrative justice in Ukraine that did the lion's share of work in the development and inception of the administrative justice in Ukraine. And I can see Dr. Stefan Hurston. Good morning, Stefan, to you. It's a pleasure to have you with us today. He was driving the effort in Ukraine, and we are sincerely grateful to you, and we bow to you with the gratitude and respect for your contribution to the Ukrainian people. So I'd like to welcome all the participants of this international workshop, wishing everyone very good discussion, sound health, and work for the development of the administrative justice and rule of law, development of the judiciary in Ukraine. Thank you. Thank you, Mikhail Ivanovich. And finally, I have the pleasure of giving the floor to Vsevolod Knязев, who is the Secretary of the Grand Chamber of the Supreme Court. The floor is yours. Good day, dear colleagues. It's a pleasure to see everyone at this international workshop. I'm grateful to all the judges, to all the colleagues who joined us today for this event. I'd like to thank the representatives and judges of the Constitutional Court. We are particularly grateful to our foreign partners named by Mrs. Danishevska and Mr. Smokovich. We are so grateful to you for joining our discussion today. Your opinion, your expert findings and insights are truly invaluable to us. Your experience is of great interest to us. The Constitution of Ukraine is the main law of Ukraine, and when we deem Constitution the main law, we give it supremacy in the national legislation. Constitution is the normative and substantive basis of the law. So the Constitution adopted by the Verkhovna Rada is the basic law in the Ukrainian country. Based on its provision, the entire national legal system rests, bringing forth laws, lower ranking statutory acts, application of the law is made, and protection of the constitutional rights and freedoms of people and citizens by the courts to assure the observation of the constitutional rights of people's sovereignty as the main prerequisite for the rule of law. The notes to Article 6 and 8 of the Constitution of Ukraine, it provides that the constitutional limits are set on the judiciary operations. The second sentence of the second part of Article 8 of the Ukrainian Constitution, it provides that turning to the court to uphold the constitutional rights and freedom is done based on the Constitution. The Constitutional Court of Ukraine, in point 4 of the motivation, the substantive part of the decision of 2011, states the following legal provisions: assertion of the rule of law in the country under Article 55 and Article 2 of the main law are about guaranteeing judicial protection of the rights and freedoms and about implementation of the mechanism of such protection. The decisions made by the governmental agencies, their actions taken as they administer their functions and also to exercise their powers can be appealed in a court under Part 1 and 2 of Article 55 of the Constitution. To implement the constitutional right to review the decisions of the governmental agencies, the Ukraine has set up the system of administrative court to that effect. A noticeable step to strengthen the safeguards of the consistent operation of the legal state was the changes made in June 2016 on the changes to the Constitution about justice, Part 5 of the Article 125. The Constitution denotes about the operation of the administrative courts of Ukraine as a constitutional foundation for the organization and administration of justice in Ukraine. The effective protection of rights and interests of both physical and legal entities from the violations from the governmental agency that would be fair and just and could resolve the conflict in public affairs. This is the mandate for the administrative court as provided by the Code of Administrative Justice of Ukraine. The analysis of general provisions of the Code of Administrative Justice indicates that pursuant to the Code, the Constitution of Ukraine, and that is stated in Part 7 of the Code, in particular, the norms of the Constitution of Part 2 about the content and safeguards of the fundamental rights and freedoms of people and citizens are the main source of law to be applied by any administrative court as they adjudicate the cases in their case line. So the Constitution states that the court will handle cases according to the Constitution. So Constitution is given supremacy in this provision and the laws of Ukraine and also international treaties ratified by the Verkhovna Rada of Ukraine. What's new in legal regulation in the Code of Administrative Justice of Ukraine in the latest edition of 2016 was the change for the better of the model of administrative justice, asserting the rule of law and constitutionality of Ukraine in the legal system to effectively protect the violated rights and freedom. In particular, we're talking the cases when there are elements of the violation of certain unconstitutional violations and unconstitutionality of certain statutory acts. The current edition of the Code of Administrative Justice, it is stipulated that if a law concludes that a law is inconsistent with the Constitution, the court would not apply the law, but instead would refer to the norms of the Constitution as a direct effect norms. When the court makes a decision, it would appeal to the Supreme Court to make the application about the law being reviewed for its constitutionality. We know that the Supreme Court makes use of the instrument, and the members of the Supreme Court have made such applications to the Constitutional Court. This construct was simplified, considering the previous construct, which existed before the Code of Administrative Justice, which provided that if a court felt a law was unconstitutional or some regulation was unconstitutional, they had to cease the consideration of the case and go to the court. But now the courts of the first, second, cassation instance have been given a very powerful tool set to apply the Constitution. So we can conclude that currently the administrative courts have been vested with considerable competencies to assert the rule of law and enforce the Constitution of Ukraine, which calls for the protection of rights and interests based on the Constitution as the main law, as the direct act. This gives us the right to conclude that currently the administrative courts, as they consider cases, are full subjects for the legal protection of the Constitution, and we've now institutionalized this. The courts can assert the ideas of the Constitution, can assure the supremacy of the human rights and freedoms and other constitutional values as they apply their powers. I had the honor of chairing the Grand Chamber. From its inception, we have applied the decisions, applied the Constitution as a direct effect act. There are some landmark cases. There have been 18 such landmark cases made by the Grand Chamber. In 9 cases, immediately we made the decision based on the direct application of the Constitution. These were cases about the social protection of the individuals who are pensioners by age, social protection of the military servicemen, internally displaced person, people living on the territory polluted by radiation, pensioners of the Ministry of Interior, pensioners of the prosecution service, civil servants, about the welfare paid to the retired judges. Moreover, I would like to refer to the provisions and principles applied by the Grand Chamber. I'll give you some insights into the cases. We applied the Article 8 of the Constitution about the principle of supremacy of law in Ukraine and direct effect. Article 19 of the Constitution about the duty of the governmental agencies and self-governance and public officials to act within the constitutional rights and the laws of Ukraine. Article 46 was applied in 9 cases about the constitutional right of the people to special protection. Article 58 of the Constitution about the prohibition of retrospective application of the acts and other regulation except when they mitigate or abrogate the liability of the persons, meaning that currently the courts of Ukraine of the first and second instance and the Supreme Court are successfully applying the provisions of the Constitution as direct effect. There is a consistent practice of the cassation court, the administrative court of the Supreme Court, grand chamber, but we do encounter certain challenges as we apply these provisions. There are some theoretical challenges and practical challenges, and I hope we'll be able to touch upon the challenges today. So I'm very grateful to the Cassation Administrative Court for organizing this event today that will apply to all the judges of the administrative courts as they apply the Constitution. I know you will have very good results based on the application of this event. I wish everyone a very good day. Thank you for your attention and wishing you a fruitful day.
Thank you very much.
Thank you very much. It's been a
pleasure to hear
pleasure.
from you.
I
I'm
know
confident
that
during our discussion of all this practical and theoretical issue, we'll have proper and interesting discussion. Now let's look at a short video. Sorry, just let's wait for a minute. Some technical problems.
Дякую.
Thank you.
Нагадаю всім нашим
Let me
нашу програму.
remind you that we all know all the points of our agenda. I will just remind you that we will have two parts. Part one is doctrine of application of the Constitution provision as act of direct effect. Will discuss the constitutionality of any law and use of mechanisms of interaction with the administrative courts with the constitutional code criteria of interpretation of the law. During the session one, to discuss the doctrine, well, why that's very important, because that was the main reason of these doubts. We also heard about some problems arising in the judicial practice, and this is also due to some recent trends in our country, which are related, first of all, with the attempt to bring the Ukrainian legislation in compliance with European standards. Another The important part is implementation of the notion of constitutional complaint in Ukraine, by which actually any citizen can actually file a claim with the constitutional court with respect to constitutionality of any legal acts. Also, another important part is Article 7 of Administrative Justice Code, which allows administrative courts, although the similar provision exists in other jurisdictions, to declare non-constitutionality of any legal act. It's evident that the direct effect of the Constitution is the principle of the Constitution. Also, Article 8 of Constitution guarantees that any actions with the court are guaranteed to defend the individual's rights. But what is our goal for today? It is to consider some very important points, like overall, the Constitution should not be a thing per se. It is aimed at protecting the rights of an individual before the public authorities. It was mentioned today that administrative law is an implementation of constitutional principles, especially the principle of the rule of law, which prevents from any abuses of power and constitutes basis for test by constitutional courts. Also, there are other important principles pertaining to constitutional principles. That's human dignity, continuity of power. We should not forget about any other special sections of the Constitution pertaining to special part of the Constitution. Also to European human rights case law, Court of Human Rights case law, which actually gives interpretation of how any constitutional provisions and provisions of the convention should protect the human rights. Well, it's clear, and we mentioned this today several times, that the Constitution is implemented through specific actions to implement and practice the constitutional rights. So there is often a point, how should we interpret the Constitution, and they become especially acute if any court establishes the fact that some legal act fails to comply with the Constitution. Today we'll talk about Article 7 of the Administrative Justice Code, provides for certain procedure and algorithm of acts to be undertaken by administrative courts if they deem necessary to declare any legal act non-constitutional. You are all aware that the courts do not apply the respective provision of the law. They should not dictate it, but they need to make respective decision to deliver special judgment, and then they might address the Constitutional Court with their respective filing. What is the complexity in application of this direct effect of the Constitution? First of all, we need to define those substantial provisions that may constitute actually the basis for a solution of administrative disputes. What cases are we talking about in practical application? Let's say even the Supreme Court has had opportunities to face such situations, which then really implied this meeting. What are the points of current work for Supreme Court and Cassation Administrative Court with the Supreme Court? This is a matter of non-correspondence between various criteria and norms which may be a substantive basis for a judgment, or cases when a court is supposed to test respective law for compliance with the Constitution, while the Constitution does not contain any special provisions allowing for such test. Let's say the public service or civil service provisions. The Constitution does not provide for any foundations of the civil service. What then an administrative court should be guided with in their decisions. Also, another case is when a provision is obsolete, or as they say, dead provisions, which are far behind the current times, so they cannot be practically applied by the courts. So what then the court should be guided with, or maybe other cases when a court is supposed to apply provisions which have already been declared as not constitutional by constitutional court before. Maybe a simpler situation when court sees clear violation of a procedure of adoption of a legal act, which then will be prevented from any further practical application. I understand there are many complexities in searching the methods and approaches of how the constitutional provisions should be applied, because the Constitution is rather the declarative document that does not contain strict regulations, because actually its provisions are then further regulated by the current law. Well, no matter how it's all interpreted by the legislation, the administrative courts are supposed to clearly protect the rights of the individuals. So what I suggest for today is that we all join discussion of these practical issues which we have been discussing at the level of Cassation, Administrative Court, Supreme Court. We can share experience so that then we can maybe even change somebody's views or to enhance our approaches to solution of certain problems. I will be thankful if you share your experience, those complications that you have faced, challenges. I'd like to emphasize that within two sessions, we have two key speakers. First one, Mr. Brook, and second one is Mr. Smokovich. They will have 20 minutes each. And other participants will have 10 minutes for their presentation. Please keep that in mind and keep with your time frame so that we have more discussions. And now I want to invite to the floor Dr. Lars Broker, who will tell us about the application of the Constitution by administrative courts in cooperation with the constitutional courts.
Dear Mrs. Chair, dear Mrs. Bilak, thank
Шановна
you
пані голово,
very
шановна
much.
пані Білак, дуже
And thank you for the invitation to this important conference and for giving me the opportunity to share our experience and our ideas as colleagues and as old friends, I may say. So let me go to the point, and you see the slide number 1. The direct validity and application of the Constitution by the administrative courts is of central importance for administrative jurisdiction and its definition of function in a democratic state governed by the rule of law. This underlines the role of administrative jurisdiction as the decisive guarantor of fundamental rights protection for citizens. The administrative courts enforce not only the ordinary laws, but flanking the Constitutional Court, also the Constitution itself. However, the implementation of this principle in practice is not always easy, particularly in terms of procedure. Fundamental constitutional principles have to be balanced. This concerns above all the interaction between the administrative courts and the actual guardian of the Constitution, the Constitutional Court. Above all, however, questions of the separation of powers arise when laws of parliament are not applied by the courts. The principles of democracy and the rule of law are thus directly affected. A comparative legal analysis will show, according to my initial hypothesis, that according to the current legal situation, the situation in Germany and Ukraine is very similar. However, fundamental differences exist with regard to the question if the procedure for involving the Constitutional Court and the relationship to the legislator and thus to Parliament. Nevertheless, on closer inspection, all of those questions are more similarities than differences, as you will see. However, I would already ask for your indulgence if I do not have 100% correct grasp to the practical application of the relevant norms of the Constitution and the administrative court rules of Ukraine. However, it may be of interest to you how German administrative judges would work in practice, especially with Article 7 of the administrative court rules of Ukraine with their prior understanding, namely quite similarly as they know it from their administrative court rules. So let's see slide number 2. First, however, to the central prior question, if you put the second slide on the screen, please. Yes, thank you. First, however, to the central prior question, does the Constitution have a direct effect on administrative law? As you see, two very famous names, Otto Meyer, the doyen of German administrative law, wrote the following famous and infamous sentence in 1924: constitutional law passes, administrative law remains. In 1959, the first president of the Federal Administrative Court, Fritz Werner, countered this with the sentence, administrative law is concretized constitutional law. This means administrative law cannot be decoupled from the Constitution in a democratic state governed by the rule of law. And in Ukraine, there is no need for a comparatively complicated dogmatic derivation of the direct validity of the Constitution as in Germany, because Article 8 of the Constitution of Ukraine determines the direct effect of the norms of the Constitution. And according to Article 8 of the Constitution of Ukraine, directly links this principle with the guarantee of legal protection and thus with the central anchor point of administrative jurisdiction and its mandate under the rule of law. This legal concept is additionally reflected in Article 55 of the Constitution of Ukraine for constitutional jurisdiction and in Article 125 of the Constitution for administrative jurisdiction. The judiciary is thus assigned a constitutionally central role in the protection of fundamental and human rights, namely constitutional and administrative justice together. from this point of view, Article 7 of the Administrative Court Rules of Ukraine are directly constitutionally underpinned. The norm clarifies that the Administrative Court may not apply a law or other legal act if it is unconvinced to a norm of the Constitution. So, slide 3, please. So what does this observance and direct application of the Constitution by the administrative courts look like? Let me point out the, I think, most important point. I call it the interpretation in conformity with the Constitution, as we say in Germany, verfassungskonforme Auslegung. A special case in the so-called interpretation in conformity with the Constitution is this principle. This principle states that in the case of several possible interpretations of a norm, preference is to be given to the one that comes closest to the Constitution and is consistent with its requirements. The aim of this method of interpretation is to preserve the norm and thus to respect the decision of the legislator as long as this is possible in terms of interpretation. However, the clear intention of the legislator must not be turned into its opposite. In this case, the limit of possible interpretation in conformity with the Constitution would be reached. All in all, the following applies in this respect. The Constitution must be observed in the interpretation of ordinary law, and its basic decisions must be enforced. In principle, the norm is to be interpreted in conformity with the Constitution. Unconstitutionality may not be assumed lightly. The principle of preservation of the norm applies. In the paper I sent to you, there are some cases of the Federal Administrative Court of Germany where you can read some cases and study it. So, slide number 4, please. In individual cases, however, the court may also come to the conclusion that the norm that is decisive for the dispute is unconstitutional. Especially if it is a parliamentary act, the principle of interpretation of powers is affected. The court comes into conflict with Parliament if it does not apply a law. In Germany, the following applies. If a court comes to the conclusion that the norm which is decisive for the dispute is unconstitutional, it must disregard it. If it is not a formal law, for example, only a statutory regulation, or if it is a formal law, it must refer the question of constitutionality to the Constitutional Court for a decision and stay its own proceedings until the Constitutional Court has ruled on the question referred to it. This is written down in Article 100, which regulates the referral procedure, assumes that out of respect for Parliament, only the Constitutional Court may declare a formal law unconstitutional and thus null and void. The Administrative Court may not simply leave the law unapplied. The so-called monopoly of the Constitutional Court to reject norms applies. In the case of other legal norms, such as statutory regulations, the same applies in Germany as under Article 7 of the Administrative Court Rules in Ukraine. The court does not apply the norm in the case to be decided if it deems it unconstitutional. The actual exciting question is then, how is the loophole in the law that then arises closed by case law in order to be able to decide the specific case? For the plaintiff as a right to have his action decided. In this respect, it must be said that Article 7 of the Administrative Court Rules of Ukraine does indeed consistently take up the idea of the regulatory loophole in substance by referring the court to analogy and general constitutional and legal principles as a solution. Nevertheless, the core problem remains that the judge, when closing the loophole, is in this respect acting creatively in law and, at least in part, putting him or herself in the place of the legislator. In my view, the solution to this problem can only be approached by the judge initially imposing a high degree of restraint to himself. The judge may only take the place of the legislator to the extent that this is unavoidable in order to enforce the Constitution and decide the specific case. In Germany, because of the above described referral procedure under Article 100, the Constitutional Court relieves the administrative courts of a great burden in this respect. The Constitutional Court cannot only declare a norm null and void, but also order its continued application for a limited time, despite its unconstitutionality, in order to prevent an even more unconstitutional situation in individual cases and/or to enable the legislator to find a new regulation itself. The Administrative Court then implements this result found by the Constitutional Court when it reopens and continues its proceedings that have been brought to a halt. The continued validity of an unconstitutional law is particularly important in the case of violations of equality. Take, for example, the case where a law stipulates that police officers receive a corresponding salary allowance, a special payment for particularly dangerous assignments in disaster situations over a period, let's say, of more than 4 weeks. Firefighters do not get this allowance according to the law, although they are also exposed to the same additional dangers and efforts. Some firefighters are therefore suing in the administrative courts. If the administrative court considers the different treatments to be contrary to equality and thus the law to be unconstitutional, there are theoretically basically 2 possibilities. The court awards the benefit directly to the firefighters as well. This is how it would actually be done in EU legislation, for example. However, this would have the clear disadvantage that the courts would slip into the role of the legislator and directly initiate budgetary expenditure. For it is also true that courts cannot print money. Another theoretical solution would be that the unconstitutionality of the norm leads to the police officers not getting the allowance either. This would indeed be a very unsatisfactory solution in practice, which is why in Germany the unconstitutionality is usually established in such cases, but the legislator is ordered to enact a regulation in conformity with the Constitution within a certain period of time. This, however, can only be done by a constitutional court. For example, declare a law unconstitutional, but order its temporary continuation. Incidentally, it can increasingly be observed that administrative courts proceed similarly in the case of legal norms set by the public administration and declare a norm continue to be applicable in order to avoid a situation that is even more unconstitutional. In my paper, there is given another example for a case like that. However, the appeal to the legislator to change the situation is very clear in these administrative court decisions. In Ukraine, on the other hand, because of Article 7 of the Administrative Court Rules of Ukraine, no constitutional court will relieve the administrative judge of the difficult task of closing the loophole. Therefore, if a constitutional interpretation of the norm is not possible, the administrative judge will have to close the loophole by ways of analogy and further development of the law. The legislator may not complain about this either. It formulated and conceived Article 7 of the Administrative Court Rules of Ukraine in this way itself. This is a de facto extremely strong role of administrative courts vis-à-vis the Constitutional Court and Parliament. From my point of view, it is not far-fetched that this may be more of a cause than a blessing, as we see in this conference, I think. So I would shorten my speech, and please take out the slide number 5, and we go directly to slide number 6 to some remarks. In the end, the question of the non-application by a court of law, or the question of the non-application by a court of a law or other legal norm that is deemed unconstitutional touches a fundamental question of the separation of powers and the rule of law, as well as the relationship between administrative and constitutional jurisdiction. How the resulting questions are to be resolved depends in each case on the specifics of the individual case. In general, and this may be my final remarks, in general, the following applies. The Constitution is to be applied and developed already in the interpretation of ordinary law. The possibility of interpreting the norm in conformity with the Constitution must be sought. The unconstitutionality and non-application of the norm is the exceptional case requiring justification. The greatest possible judicial restraint must be exercised in closing a loophole in the law that is created by the non-application of the norm that is decisive for the dispute in the individual case. The judge must not put himself in the place of the legislator. Article 7 of the Administrative Court Rules of Ukraine takes this idea into account, but without prescribing a specific examination program for the judge. Article 7 of the Administrative Court Rules of Ukraine only obliges him to follow the general legal principles mentioned therein. The fact that he has to decide the case according to Article 7 before involving the Constitutional Court, in contrast, in Germany, the proceedings are suspended according to Article 100, puts him in a strong but also difficult and challenging role. Irrespective of this, or precisely because of it, the following applies. There is a constitutional need not to ultimately withhold the final decision on the constitutionality of a law from the Constitutional Court. Since the Constitutional Court decides with effects inter omnes, Article 151 of the Constitution of Ukraine, this also ensures equality in the application of the law and thus compliance with an elementary principle of justice. As you see on the slide, as the Federal Constitutional Court of Germany in 1980 pointed out very clearly and according even to the Bible. So the development of the law by judicial interpretation And this is what our topic is dogmatically about in its core, is one of the traditional tasks of judiciary. However, it is an absolute exception and demanding. In this regard, the Federal Constitutional Court of Germany has stated that the development of the law by judicial interpretation presupposes a regulatory loophole and must be oriented on terms of content to the purpose of the statutory regulation and the constitutional requirements. The limits of the development of the law by judicial interpretation are even narrower if they lead to deterioration of the legal situations of the citizens. And this is exactly what the Supreme Court of Ukraine exemplary did with its ruling of April the 21st in 2021, according to the question of the retirement age of a person being 55 or being 50. So in the end, it's the same approach to the problem in Germany as it is in Ukraine. Thank you very much.
Пане Брокер, дякуємо.
Mr. Broker, thank you for your insights. Thank you for your presentation. And I have a very brief question to you. Just one question to you. We will also have a question and answer section afterwards. But now, Mr. Broker, when you say that the judges should be creative as they interpret the law or a separate norm of a legal act, what do you mean particularly? Because generally any interpretation brings a new element into the understanding of the law. So my question is, what should the judge be governed by when he needs to be creative in the application of the law in the German legal system? Thank you.
So first of all, that's what I wanted to point out, is he has to find the solution in the ordinary law. He has to look what was the exact intention of Parliament, and then has to do his interpretation according to the Constitution. He has to find a possibility of interpretation which is as close to the Constitution as it is possible. But therefore you have to decide a case. You cannot say, I don't decide in this case, because that's your job as a judge. You have to be, if it's necessary, creative. So this means you have to find a way that maybe the Constitutional Court did not see or find or pointed out until yet. So it's on your turn, and the Constitutional Court maybe later will discuss what you created. So it's always thing of discussion also between courts. They discuss and they talk about their rulings. So.
Дякую. Дякую.
Thank you very much. And now, I'd like to give the floor to Vasyl Lemak, the judge of the Constitutional Court of Ukraine, who will talk about the direct application of the Constitution of Ukraine, the key challenges of theory and application of the law. You're given 10 minutes. Thanks, everyone. Thank you for the invitation. I'd like to welcome all the participants And surely 10 minutes are far too scarce for me to shed some light on the problem that we all share. And it's a challenge for both the constitutional jurisdiction and administrative jurisdiction. And by this, I mean the direct effect of the Constitution. And nevertheless, I will give it a try. And before I go into the merits of the matter, I will make some preliminary remarks. Let me start by saying that Part 3 of the Article 108, comprising two elements, we keep saying that it is intended to separate and say that the Constitution isn't declarative, it can be applied directly. However, my first remark pertains to the fact that the Constitution should be seen as an integral, holistic document, and this provision of the Article 108 is to be seen holistically, integrally with all the other provisions. And I would formulate it the following way. It says, Part 3, that the norms of the Constitution of Ukraine are the norms of direct effect. However, we should read it somewhat differently, that the norms of the Constitution are the norms of direct effect if the Constitution does not provide otherwise. And let me explain what I mean here. I mean that dozens of constitutional norms refer to the laws. And we need to know that the same ways we cannot ignore them. And the Polish constitution is worded in a similar fashion. They say that its norms have direct effect unless stipulated otherwise. We don't have this caveat in the end, but I think we should interpret it in the similar context of the constitutional matter. My second remark deals with the following. I'm going to refer to Article 7 of the the Code of Administrative Justice. It's not for me to teach the wisdom to the judges of administrative jurisdiction as to the way they should read the administrative code. But I feel that this phenomena, the direct effect of the Constitution, has an autonomous constitutional meaning. By this, I mean, it's not important the way the legislators perceive it today. I'm not sure they comprehend it in full. So what I'm going to say will be a reflection of my understanding of the phenomenon. And one third remark that I would like to make. We should recognize that the key aspect of the direct application of the Constitution is the case law. And it's not only for the administrative courts, it's also for the courts and judges of all the jurisdictions. Indeed, how should the judge act when he is faced with a case and a person is substantiating his claim by referencing a norm enshrined in the Constitution? I will say that the academic and practical discussion is in its early stages, and the judges of the administrative justice and other judges are very proactive, unlike the constitutional judges. I'm reading one of the publications, and Miroslava said that we'll be able to publish our contribution, but I'm reading from a publication of one of the judges of the higher court. They're saying that the constitutional control is being watered down, and the constitutional court isn't the only subject of the constitutional control, and they say that the other parties should be their general jurisdiction courts. So if we do raise the topic, we need to be very cautious and always go into the merit, because the naming isn't as important as the sense we vest into the terms. So the direct effect of the Constitution is a very complex phenomenon. And I would isolate the following aspects. Firstly, we need to understand that the direct application of the Constitution isn't only about application of the Constitution by the courts. The Constitution has direct effect, and it doesn't need to be applied even. It is manifest through different subjects, being governmental agencies exercising their powers, such as also individual subjects enjoying their rights. And then the Constitution is manifest, and this is the manifestation of the direct effect of the Constitution. Next, let's look at the direct effect of the Constitution when it is applied by the courts. There, I would like to underline that we should know when the courts apply the Constitution directly, we should look at the delineation of powers between the general court and the constitutional jurisdiction. I don't want to be ironic, but the Article 150, 151, 151 and a note to it also have the direct effect as others, and they provide that the Constitutional Court provides constitutional review, and the norms of the Constitution have direct effect. And this is underpinned as the powers of the Constitutional Court. The second element is how should a judge of a general court consider before applying the Constitution directly. I'm pressed for time, but still I would like to make a few highlights. In my opinion, the first thing he should consider is the nature of the Constitution. The Constitution, because of its normative structure, is in many ways unlike the other laws. By this I mean, we should perceive it differently because of the three normative blocks it comprises, like the principles of law, the constitutional policies that I will refer to later, and the specialized norms. The two normative blocks are too complex for the immediate application by the general jurisdiction courts. The principles of law are the very values that could be expressed implicitly or explicitly, and the judge could apply them directly, while the constitutional policies are constructs that may not often be expostulated by the doctrine, but are intended, or like the program settings enshrined in the Constitution, like the government supports motherhood, or the government addresses its policy towards other goals. But these normative constructs always have a value dimension. And there's a third element as well. And here we mean about the textual explicit constructs of the Constitution that can be applied by the general jurisdiction court directly, same as the text of the laws. So what do I mean specifically? Which constitutional norms do I mean? To give you an example, a judge may not belong to a political party. These are the wordings that are most often linked to the legal duties. And the legal duties would include prohibitions. And this is stated explicitly so. So we can just interpret them on the face of them. Secondly, I would consider provisions that do not enshrine some direct legal duties, but are expressed in general terms, contain some time limitation or some quantitative indicators that can be applied by the general jurisdiction courts as they would apply a law. But even where it is seemingly formulated simply, we still have to be very cautious because Part 2 of the Article 24 lists the parameters against discrimination. There are 9 parameters written in simple words that can be applied by any judge, but they would also consider other elements. And I will tell you what we should do if the judge. I can give you just a few more minutes to conclude your presentation, I'm afraid. Then I will just say in conclusion, how do we segregate the simple text of the Constitution, which is very explicit from others? My advice would be to draw a parallel with the Van Gaeg criteria. This is a mechanism that defines the criteria for the way the EU, in the EU, national courts can directly apply the EU laws regardless of the form of the law. So these criteria are many, and it comes from the very first cases of the EU court in 1863. And in particular, it's stated there that a norm can be applied directly when it has the same character that permit applying it in this case. So the norm has to be clear. It has to contain a negative duty. It should have no limitations, etc. I'm grateful to you for your attention, and I'll be very happy to take your questions. And I'll try to publish the text of my presentation.
Пане Лемок, дуже дякуємо. Сподіваюся на ваше розуміння. Цінуємо ваші підходи, думки, поради, враховуємо. Одне таке маленьке запитання в продовження.
We are very grateful to your comments and recommendations. On the one hand, we are talking about the clear distinction of the functions of the Constitutional Court and the functions of the administrative justice, but still we know that they are closely interlinked. From your speech, it's noticeable that without the creative approach, the administrative judges will not be able to address their task. So by applying these provisions,
so here we can use these programming provisions. So if we apply programming provisions, in fact, we create the law because we actually apply Constitution to generate specific substance of a specific dispute. Doesn't it look like we were applying the constitutional provisions based on any interpretations available from the Constitutional Court, and where the Constitutional Court has not given such an interpretation? And you remember our first meeting, we had series of such cases. We agreed that such interpretation should be admissible. But we need to keep in mind that there may be mistakes, or even administrative court may have an opinion different from opinion of constitutional court with respect to specific provisions of the constitution, no matter whether we are talking about some provisions related to values or programmatic points or policies or cleared dispositive provisions. So within this context, what do you think is the way out of the situation? Is there any limit for this interaction? Thank you. See,
Який рецепт виходу із ситуації? Ну, по-перше, дивіться, не треба драматизувати, що
we shouldn't really make it a big drama, you know, as if each case would have this problem. I think similarly to other countries, more than 90% of the cases would not contain any disputable points of this kind. Most of them are quite simple cases where there are no doubts about applicability of the direct applicability of the Constitution. But there are several key blocks. What is the way out, as you asked? Well, so I mentioned that number of times. I intended to say today that because of the time limitations, I couldn't say that. So if a citizen wants the court to apply certain principle, then what should a judge should be based on this specific demand, especially if there is no written doctrine available with this regard. Specific doctrine, of course, the judge should do it by himself or herself on the basis of other sources of constitutional law. Indeed. Well, that's what I wanted to say, that the mechanism of this chain through the Supreme Court and the Constitutional Court, I think here is, well, sorry, I'm sorry. Yes, just unless we have, established case law at our level, that Constitution should be applied on the basis of other sources of constitutional law. First of all, based on the International Convention on Human Rights, the respective practices, etc. So, in its totality, probably a judge would still have a chance to consider the case. Well, I'm very thankful to you. Please stay with us. I want to invite to the floor Mr.
Дякую, шановна пані Білак,
who will talk about
Глова
Storkos, who will talk,
секретар Князев, шановні колеги, судді.
esteemed colleagues, judges.
Дякую за запрошення взяти участь у
Thank you for this
конференції. Дуже
invitation to
приємно.
take part in your conference. It's a real pleasure for me.
I am in a bit particular situation here, although I have been invited to present Lithuanian approach. I'm no longer a Lithuanian judge. After having finished my term in office as president of the Supreme Court of Lithuania, I am a judge of the European Union. But certainly, I remain aware of the problematic of direct application of the constitution in Lithuania, and I'm happy to share it with you. I know my time is very limited, therefore I will only concentrate to some basic points. As in the case of Ukraine, Lithuanian system is also based on the direct effects of the constitution. The constitution is treated primarily as an act of legal norms. Its norms are directly applicable in the activities of state institutions, agencies, and courts, certainly. However, what does it mean in practical terms? Does the direct application of the constitution by ordinary courts refer to the power or duty of ordinary courts to refrain from applying unconstitutional legislation? Does it refer to the possibility to satisfy the claim directly based on the constitution? perhaps the direct application of the constitution may take several forms. Before I address these questions, I will briefly mention that the legal system of Lithuania is based on centralized model of constitutional control. The Constitutional Court decides whether laws and other acts of the parliament are in conformity with the constitution. A judge cannot apply a law that is unconstitutional. Where there are grounds for believing that a law that should be applied in a particular case is unconstitutional, the judge shall suspend the proceedings and refer the matter to the Constitutional Court for a ruling on the constitutionality of the law. And there I will briefly mention the jurisprudence of the Constitutional Court, which has emphasized that where the court hearing a case is in doubt as to whether the law that should be applied in the case is unconstitutional, it is not only entitled, but also obliged to ask the Constitutional Court to rule on the constitutionality of the law in question and to suspend the proceedings before the court until the Constitutional Court has ruled on the question. Only in this way can the necessary conditions be created for the Constitutional Court to exercise constitutional justice and to decide whether the law which is to be applied in the case is compatible with the Constitution. Hence, the right of referral has to be transformed into the duty to refer. And that brings me to the first type of the direct application of the Constitution, which is a refusal to apply a provision that runs contrary to the Constitution. There is no controversy in Lithuania about the duty to refer the question of the constitutionality of the law applicable in the case to the Constitutional Court. No ordinary court can declare the law unconstitutional, nor simply disapply it on the same argument. On doctrinal level, the question has been asked whether obvious unconstitutionality of a provision constitutes sufficient ground for refusing to apply it without referral to the Constitutional Court. However, it never happened in practice. Even in a handful of cases where after annulment by the Constitutional Court, the legislator enacted the provision of identical or very similar content, the courts follow the same pattern and refer the question of constitutionality to the Constitutional Court. Such centralized model contributes to consistency and predictability of legal system. The second and the most common type of the direct application of the Constitution, and I'm sure you do it on a daily basis in Ukraine, is co-application of the provisions of the Constitution and hierarchically lower legal acts. We may call it interpretative co-application. This consists of determining the proper meaning of a statutory provision with the use of a constitutional provision. This is particularly useful when a statutory provision can be interpreted in several different ways. The court bases its judgment on a statutory provision interpreted by means of a relevant provision of the Constitution, as rightly referred by President Brocker. However, there are limits in the application of this method, as an interpretation cannot change the content of a statutory provision. Otherwise, a legal question would need to be addressed to the Constitutional Court, given that only this court is competent for carrying out a final adjudication on the constitutionality of such a norm. The third type of the direct application of the Constitution occurs when a court uses a provision as a provision of the Constitution as the sole basis for a decision. Such an application entails the need for two conditions to be fulfilled. First, that the constitutional provision is sufficiently clear, sufficiently specific, and secondly, that there is no statutory regulation in a given area. As Napoleon Bonaparte said that a constitution should be short and obscure. And in practice, indeed, constitutional provisions are hardly ever specific and precise enough to act as an independent basis for a decision. However, it may happen on specific occasions. I will briefly present you a recent example from the jurisprudence of the Supreme Administrative Court of Lithuania, which confirmed a direct applicability of the constitutional provision concerning the right to apply to a court in the absence of any specific regulation in this regard. The case is related with a very problematic situation caused by the migration crisis on the border between Lithuania and Belarus. You are certainly aware of this situation. In reaction to this crisis, the parliament enacted amendments to the law on legal status of foreigners. According to them, in the event of a state of emergency declared as a result of mass influx of foreigners, those persons who have applied for asylum shortly after illegally crossing the state border, until a decision to admit them to the Republic of Lithuania has been taken, they shall be temporarily accommodated at border control posts or transit zones without being granted the right to move freely within the territory of the Republic for a period not exceeding 6 months. There is no clarity, there is an argument about whether this temporary accommodation amounts to detention or not. In any case, no judicial review is provided against this remedy in the law. However, the Supreme Administrative Court confirmed the right to access the court in these situations based on directly applicable provision of the Constitution, interpreted in the light of the jurisprudence of the European Court of Justice and the European Court of Human Rights. As a very final remark, I would like to stress that in recent years, the number of legal questions submitted to the Constitutional Court is decreasing. This shows that judges independently solve doubts arising in the course of adjudication using a pro-constitutional interpretation of a provision as the basis for their decisions. There might also be another reason for that. We live in a multi-layered constitutional order in which rights are protected not only by national courts, not only by constitutional courts, but also by international courts, such as the Court of Justice of the European Union or European Court of Human Rights. And the constitutional courts may see the area of their adjudication decrease as the ordinary courts, for instance, they may choose to submit certain questions not to their domestic constitutional court, but for instance, where the European Union law is applicable, to the European Court of Justice. In the case of contradiction of the national law with the European Union law, the latter prevails and the national law shall not apply, at least in theory. This, however, is the subject of another and much broader topic. I stop here and I thank you very much for your attention. Дякую за увагу.
Дякую, пане Мелкусе, за вашу думку.
Thank you very much. Well, are you done with your presentation, or I misunderstood? Yes, you're done. Okay, thank you very much. So I'm sure you'll have many other opportunities to join our discussions. Now, what I'd like to specify, you just mentioned that the number of applications with the Constitutional Court is decreasing. Could you please specify what do you think is the reason for this decrease of because the national courts have are doing now better in applying the ordinary legislation with consideration of constitutional provisions, or maybe because more and more cases are resolved at the international level with consideration of European legal provisions and other institutions, judicial institutions in Europe. What do you think prevails?
Thank you very much for your question. I think that the first reason is the basic reason for lowering the numbers of the application to the Constitutional Court. We are getting smarter and smarter every day, and the judges use a method of use different methods of interpretation in their daily work. The need to interpret ordinary laws in the light of the provisions of the Constitution is a method which we all are very well aware of. In the case that there was a previous question asked to Mr. Broker about the creativity of the judge. Yes, the creativity has to know its limits, and we also need, as judges, to determine whether a certain loophole, a certain gap in the law is unconstitutional, or it's a very normal situation to use our interpretation to fill the loophole, which is a daily bread of our judges. Only in the case where the loophole in the law is unconstitutional, the real question arises how to fill in the loophole by the different methods of interpretation of the law. But I would say certainly the creative and pro-constitutive I'm sorry, interpretation by the courts is the main reason why the constitutional courts, at least in my country, have less and less work to do.
Пане Норкусе, щиро дякую, що ви в курсі і тримаєте.
Again, thank you indeed. Thank you very much for really continuing monitoring situation with your courts. I hope that in spite of COVID, we'll still have a chance to discuss very specific case law of the courts with respect to interpretation of the loopholes that you mentioned. I hope we'll have opportunities to share our experiences with this respect. And because Article 7 of Code of Administrative Justice is still there, and we need to look for the proper ways to find the solutions. So now I'd like to offer the floor to Mr. Justice Gorodovenko, who will talk about direct effect of the Constitution of Ukraine.
Ms. Miroslava, thank you. Esteemed Ms. Miroslava, esteemed dear guests, esteemed national and international expert, esteemed colleague from the Supreme Court, I'd like to start by expressing my gratitude and respect and say that I'm privileged to speak at this event and to say that both the first and the second event are very important, and very importantly, they will be helpful to the Ukrainian judges, helping them see some road signs as to the way they should apply the Constitution in their everyday work. It's a pleasure for me to say that the team of organizers and Ms. Miroslava personally, who drafted the agenda for this international workshop, have designed the agenda so that we are picking up from each other, and the questions posed by Miroslava will be reflected in my presentation, as in my opinion, they are very practical, and they statement made by Vasil Vasilovich are just as important, but we'll be able to distinguish the clash of the jurisdiction that they had talked about. As for the question of the direct effect of the Constitution, I'm not going to focus on it, as it's been broadly covered in the doctrine, in the academic presentations, in the speeches of the judges of the Supreme Court, and we have to thank the judges of the Cassation Administrative Court that have done a great deal to complement the academic doctrine of the constitutional law, and their jurisprudence is just as important as the articles they publish that we look forward to. But most importantly, this doctrine is reflected in the decisions of the court, which are just as important. And I would also like to say that the Constitutional Court, in the paragraph of the second subpoint of the motivational part of the decision, as of 2016, provided a definition of the direct effect of the Constitution by stating that this means that the norms are applied immediately. The laws of Ukraine and other laws can only develop the constitutional norms and not change the content. The laws of Ukraine and other legal acts can only be applicable in as so far they do not contradict the Constitution. It's been several years, and I can say so with certainty that we've been discussing the matter, and Albert Anatolich will make a statement that this stems from the constitutional changes of 2016 and their reflection in the Ukrainian law and the constitutional doctrine. Let me put it this way. Some lawyers believe that the operation of the court, as they do the constitutional challenge, are considered an intermediary constitutional control. It's been stated by a number of previous speakers that the administrative courts are already performing preliminary constitutional control, while the final constitutional review remains with the Constitutional Court of Ukraine. And therefore, as Miroslav was saying, that we'll be talking about the need to isolate interpretation as a separate topic. However, we should talk about the direct application of the Constitution. And this brings me to the statement made by the 8 judges of the Cassation Court that use a term called that apply the Constitution as an direct effect act, and that the means of the application is in the judicial interpretation. So let us talk about the judicial interpretation and some changes in this arena after the reform of 2016. It should be stated that we should do a retrospective into the way the Constitutional Court has been using the interpretation as a tool. The official interpretation of the Constitution, as well as jurisprudence and constitutional review based on constitutional complaints. And in these cases, we see the clash of jurisdictions. In these cases, a specific methodology is applied, like the language analysis, historical, and other interpretations that can interrelate in different ways. And following 2016, following the reform, the case about psychiatric assistance became the landmark case when the Constitutional Court formulated a novel concept or novel doctrine for the interpretation as the understanding of the constitutional values in link with the international human rights standards enshrined in the international treaties and their interpretation of the international organizations. He acted as a critic of the provision about a friendly treatment of the international law. In 2016, the Constitutional Court set this right, and it means the friendly treatment of the interpretation of the convention. And therefore, this interpretation of the international institutions is referred to by the Constitutional Court as they interpret the provisions of the Constitution. So, this is a binding element, but we have said that according to Paul Ricoeur, the French thinker who came out with the balanced Germanetics, believing that the multitude and even the conflict of interpretation isn't a drawback, but is an advantage of interpretation. So when the two courts, the Supreme Court and the Constitutional Court, do the interpreting, they can have a clash or conflict of interpretation. So the Constitutional Court and the Supreme Court may have a conflict of legal interpretation, and this is seen in cases heard by the Supreme Court about the constitutionality matters. This is in the very nature of the interpretation of Constitution, which is abstract in its nature, but this legal interpretation conflict can also be due to effective prevention mechanism vested in the Ukrainian legislation, as these mechanisms are used at the discretion of the Supreme Court as they aim for consistent interpretation. It was very interesting for me to hear some suggestions, and we can say that when we talk about international cooperation with the constitutional courts, then the Federative Constitutional Court of Geneva is one of the model courts that we are taking after. And I'm very grateful to Lars Brocker for his responses, who referred to the cases of his own Constitutional Court and the Constitutional Court of Germany as to how they resolve the conflict when it arises, and also the methodology of doing so. Also, another very interesting question was raised by Norkus, and I know that after me, there will be a systemic address from Georgi, who will speak of the Georgian experience, and I know my time is up. I'm into the last minute of my presentation, but I'd like to give two specific examples to give us some understanding of what we mean by potential conflict and how we can resolve it. In my presentation, I dealt with administrative courts, but we should say that it wouldn't be a ground for the clash of Supreme Constitutional Court, but we do have it in the commercial court. So there's a particular case about the term of limitations, about the applications to the notary based on the requirements of prohibition of discrimination, and interpretation of the European Court of Human Rights came to the conclusion that for the legal entity creditor would be discriminative compared to the physical entity debtor based on the status. and for the legal entity creditor, giving a longer term to apply to a notary about the enforcement of the debt compared to a physical entity creditor is a discrimination of the physical entity, is a discrimination based on their status. And this is something I'd like to say, because this assessment of discrimination is made in the light of the constitutional principle of equality, which has been done on a number of occasions. But this is abstract, as we may say, but now we're seeing this applied directly. And in 2020, the matter was resolved in a completely different fashion, saying when the regulations for the notary operations and the terms of limitations, when the notary can enforce an action, there is a clear distinction based on the status of the entity, and this disputed provision of the law is a regulation and exercise of the Ukrainian parliament of its powers to define the procedures for the operation of the notary under the Article 92 of the Constitution of Ukraine, and this rule allows the arbitrary interpretation. So in these two cases, completely opposite conclusions were made. And finally, I know that we are pressed for time, but still I'd like to suggest a mechanism which isn't unique to Ukraine, but an option of how to resolve the predicaments when there's a clash of jurisdiction and we have a conflicting application of the provisions of the Constitution, and more so have conflicting interpretation, a trespassing into the competence of each other. So I would suggest we follow the principle of constitutional reserve, and the Constitutional Court follows the same principle of constitutional reserve as they apply the law on the Constitutional Court. There hasn't been a case where the Constitutional Court would rule on the constitutionality of the norm, but the falseness of interpretation, because the interpretation has been inconsistent with the Constitution. So as we have international partners with us during this workshop, I will say that constitutional and institutional dialogue between the Supreme and Constitutional Court is in place. We have effective working mechanisms as exemplified by this international workshop we're having today. Thank you for your attention. I know that this is only a tiny step towards the chance to address the problem. But hearing our foreign colleagues, we are seeing some specific solutions and some specific methods to avoid such clashes. Thank you very much for your attention. Thank you for your presentation. We are looking at our watches. We are over the time limit. I'm sorry about this, but the interest in the presentation is so keen and the time really does fly. And now I'd like to give the floor to Georgi Poposhvili, who will make an address about the challenges of Constitutional Court and General Jurisdiction Courts and give us a Georgian context. The floor is yours.
Okay. Дякую, пані Білак.
Thank you, Pani Bilal. Greetings to the participants.
З Киева, из Конституционного суду. И я будущем надеюсь, что постепенно мы потихоньку уже перейдем уже
that we'll soon be transitioning to the face-to-face communication, and we'll have a chance to discuss these key matters in person.
тоже не меньше интересные вопросы будут подниматься, и, конечно же, я думаю, что это такой вопрос, что за 10 минут нельзя исчерпать.
This is a matter that cannot be addressed in 10 minutes I was given.
Аспект передать только маленькую часть.
And we can only shed some light on some elements
Немецкий, литовский, украинский особенно.
and add to the highlights shined by our Lithuanian, German, and Ukrainian participants. We can talk about the relations between the constitutional courts and courts of general jurisdiction.
Чей представитель, господин Ткаченко, здесь присутствует, который дал мне возможность от их беседы выступать. Сейчас я очень
grateful for my opportunity to present,
и потом в будущем будет возможность еще встретиться.
We'll have another chance to meet and discuss it in greater detail.
Since the establishment of the Constitutional Court of Georgia, just less than 5% of the cases decided by the court were instigated by the referral submissions from the ordinary court, so-called instrument of exception of unconstitutionality, which was discussed by the colleagues previously. You know that Italy is the most vivid example where the most of the cases are coming from ordinary courts. But in Georgia, of course, 90% more cases are coming from individual applications by physical and legal persons, and just less than 5% from the ordinary courts, and less than 5% by governmental agencies entitled to appeal to the court. So our politicians are very passive in this regard. So as to the legal acts that govern for the preliminary reference procedure, the organic law both of the Constitutional Court and the Common Courts stipulates that when a judge, while deciding a case at hand, may have a suspicion that an applicable law could be in contradiction with the Constitution, a judge shall suspend the case and refer it to the Constitutional Court. As it was mentioned by our Lithuanian colleague, in Georgia, it's the right, not the obligation. So in some countries, it could be that the judge is obliged. In Georgia, it's not obligation. So that's why in different times, in different periods, judges are sometimes active, sometimes very passive, but mostly passive, of course, judges of ordinary court. Not passive, but they don't like too much show that they don't understand any case in terms of constitutionality. And they are a bit, restrained to apply to the Constitutional Court. In most cases, it's done by the Supreme Court. Which applies, but any judge may apply to the court directly. The idea is, of course, clear behind, as argued elsewhere, is that ordinary courts are believed to be well-informed and capable of making valid requests. Therefore, ordinary courts serve as an initial filter and can help minimize the number of vexatious or repetitive requests. From our experience or effectiveness of the preliminary ruling procedures heavily relies on the capacity and willingness of the judges of the general jurisdiction to identify potentially unconstitutional normative acts and to submit preliminary questions to the court, the Constitutional Court. It's noteworthy in this respect that Constitutional Court of Georgia has developed in a recent decade, or about 15 years, the notion, so-called normative content of the provision. After developing the mentioned notion, the Constitutional Court can evaluate constitutionality of only the normative meaning of the provision that is problematic for the complainant. The idea of normative content is based on a simple assumption that the provision is not merely the text written on paper, but its substance, actual regulation, a set of rules established by it. Therefore, the court has developed the case law to the point where it is now authorized to separate different normative meanings from the same text, and if only some are problematic, declares them unconstitutional without invalidating remaining normative substance of the written provision. The execution of standards of the Constitutional Court in actual cases, as noted above, is up to the common courts, courts of general jurisdiction. The general courts interpret and apply the laws adopted by the lawmakers, while the Constitutional Court rules on compatibility of the law with the Constitution. However, the division of competencies is not always that simple. In order to check constitutionality of a provision, the Constitutional Court is in need to interpret the disputed law, determine their meaning, and then, by elaborating on the later, evaluate its constitutionality. The issue becomes complicated in cases when the interpretation of a disputed vague legal provision made by the Constitutional Court does not match the interpretation made by the general courts. In such cases, the Constitutional Court faces a dilemma of whether it should interpret the law as it considers to be correct, or to take interpretation made by general courts as a guiding source of finding true meaning behind the legal provisions. The Constitutional Court, in one of the recent cases, not recent, but 2015, indicated gradually that the general courts, within the scope of the competence, deliver a final decision on normative content of the law, on its practical application, therefore on its enforcement. Consequently, the interpretation of the legal norms made by the general courts has huge importance for determining the real content of the law. As a general rule, the Constitutional Court considers and assesses a legal provision with the same normative content as it was applied by a general court. By this statement, the Constitutional Court underlined that in principle, it will understand the meaning of a legal provision as it is interpreted by the general courts. However, in the same judgment, the Constitutional Court indicated that in several exceptional cases, it's authorized not to follow the general court's interpretation when the court is, if it's clearly unreasonable. The measured approach is an important step forward for increasing effectiveness of constitutional control, enabling the Constitutional Court to have effect on individual cases decided by the general court via evaluating the constitutionality of the law as it's applied in practice. Just to show one of the examples in which cases sometimes the general courts try to apply to the court, in one specific example, because of this case, there were different referrals from different judges. The foregoing problem of understanding the standard by the courts of general jurisdiction as laid down by the Constitutional Court became vivid and is a good example in a number of cases that concern initially the constitutionality of criminal sanctions for the consumption of marijuana, and in subsequent case law to the decriminalization of consumption of marijuana and other soft drugs. Namely, in the original case of 2015, regarding this matter, the Constitutional Court declared unconstitutional specific articles of criminal code which provided imprisonment from 7 to 14 years for purchasing and owning up to 70 grams of dried leaves of cannabis for personal use with regard to the constitutional guarantees against inhuman and cruel punishment. The court noted that in determining criminal procedure policies, the state has a broad margin of appreciation when deciding what acts to criminalize and what the punishment for that should be. However, state discretion is not unlimited. The state must select the level of amenability before the law, which is adequate and effective to neutralize risks coming from the action in question. Furthermore, the state cannot interfere in human freedoms and rights more than it's objectively required. So the court concluded that when the threats of selling it and damaging the health of others are only hypothetical, restriction of liberty for an act that only damages the health of a person committing the act is disproportional and inadequate punishment, which violates specific articles of the Constitution, right to dignity, prohibition of inhuman and degrading punishment. This case has become the reason of misunderstanding in many cases by the courts of general jurisdiction. And the common court judges struggled to comprehend the applicable standard laid down by the Constitutional Court. The common court judges did not really know how to directly apply the ruling in a numerous constitutional ruling of the Constitutional Court in numerous drug-related pending cases where the subject matter varied from different amounts of possessed cannabis and ranging to the substance of a drug in question, moist or dried cannabis. In the legal sense, these different scenarios give different normative meaning to the disputed legal act, thereby posing an important questions to the common court judges whether to directly apply the constitutional standard as determined by the Constitutional Court and resolve the pending cases, or to suspend the proceedings and apply to the Constitutional Court with a submission. But in most cases, the judges applied to the court, so referred the cases to the Constitutional Court. The Constitutional Court at a certain point in time become overwhelmed with referrals from because of these cases. It's worth noting that in its subsequent case law, in absence of much needed legislative reform in the field of criminal justice in respect of drug-related offenses, the Constitutional Court broadened the approach it had taken in the original judgment. The Constitutional Court further noted in the latest, one of the latest judgments, 2018, the court, upon this subject, has expounded a more general constitutional standard that the harm emanating from drugs, they do not cause individuals to become addicted quickly and or cause aggressive behavior when used was not sufficient to justify the imposition of a sentence. So the court stressed that the criminalization of drug use that does not result in developing addiction in a short period of time and or does not result in aggressive behavior does not serve the protection of public order and security. Therefore, criminalization of the use of narcotic substances was limited to situations where it protected public health. The production, purchase, storage, and narcotic drug for personal or single use, however, only possesses minimal hypothetical risk. For these reasons, the court concluded that imposition of prison sentence was disproportionate and actually it decriminalized usage of soft drugs, so-called soft drugs. Separately, the court addressed the approach taken to highly addictive drugs, and in these cases, the court agreed that the state may interfere and to impose punishment for serious drugs. So to conclude, it can be said that the Constitutional Court's interpretive approach helps to ensure the Constitutional Court judgments in Georgia more effectively enforceable in practice, and individuals affected are better equipped to get a proper redress in the courts of general jurisdiction. Although questions still persist in relation to the comprehension of constitutional standards by the common courts, and also due to inconsistent approach as to when to resort to the constitutional submission referral mechanism, exception of unconstitutionality. Constitutional Court's position in the context of making constitutional standards more applicable in real cases has been solidified. This is the illustration of the evolution of constitutional case law in a way as to provide viable normative framework for interaction between the Constitutional Court and ordinary jurisdiction in order to bring the constitutional provisions closer to actual cases, as well as increase effectiveness and consistency within the national legal order. Дякую.
Thank you. Are you done with your presentation?
Yes.
Так,
Шановні учасники,
as the participants, we are about to move to discussion, to Q&A session, because there are many questions and comments in the chat. But before we do this, I have a short question to Mr. Papashvili, if I may. In your presentation that you shared with us, you note that the Constitutional Court, when checking or implementing the constitutional control, if I understood you correctly, very often uses this legal content. I mean, as far as I can understand, applies very narrow approach and looks exclusively into specific cases, specific dispute, which have been considered by courts. Isn't it too much of narrowing? Then how would the principles of the rule of law should be applied, and how, if you're limited just with merely text of the legislation, or maybe Constitutional Court uses also any other tools, and since their judgments are binding, and actually maybe the court uses any other tools to review such disputes.
Thank you. Of course, the court uses different methodology in interpreting the legislation, but in terms of this new approach, when the court decides the case based on normative substance, this means that if sometimes court faces the dilemma that the text of the law is correct itself, but its application by the administrative agencies or by the courts of, with the full respect, of course, by the courts of general jurisdiction, in some cases is unconstitutional. And the court had faced dilemma whether to annul the law, which is okay, or not to annul and just saying hypothetically in the basic part of the decision, okay, the law is good, but it's not, application is not good, but nobody reads this basic part. They read just the final decision of the Constitutional Court. So that's why we choose such application that application of the law in specific areas, in specific cases applied by the courts are unconstitutional, not touching the other areas of application of this law, which works quite well in Georgia. At the beginning, of course, it was problematic, especially for parliamentarians, because when you read that the code says that the text is constitutional, but its application in the parenthesis says that its application in these cases is not constitutional. But step by step, everybody learns it. It's okay. It works well for everybody.
Дякую.
Thank you. We understand. I'm advised here prior to specify some points. There was a question to Mr. Norkus. Just a minute. Cannot find it so far. Just a second. Okay, I can see it now. The question to Mr. Norkus, is it possible to deem similar by the content two notions: law is not constitutional, or this act counters the Constitution? That's whether two statements are absolutely similar. By the way, Mr. Norkus, I'm happy to start with this question because this question was posed by the secretary of our chamber.
Madam Bilak, I'm very sorry. I'm not sure I understood the question well because there was a little bit of sound problem. Could you repeat the essence and I'll try to...
So the question is very interesting and important. What would be your answer? But it will depend on translation, of course. Our Article 7 has a number of constructs. It defines the incompliance of a provision with the Constitution, and also it has the word countering or contradicting the Constitution. My intention was to raise this issue in the section number 2. So do you believe that these 2 points are similar, not complying with Constitution and countering the Constitution, because actually in our dictionaries, these are 2 different words? Can you see any difference between these 2 words? If you need some time to consider it, we can give you some time and then get back to this question. Or maybe you can give a written answer, whatever you prefer. Thank you.
Well, thank you. I'm not sure I am capable of going into the linguistics either of Ukrainian or English language. For me, non-compliance and being counter to the Constitution are pretty much synonyms. But perhaps there is a slight nuance which I cannot feel, and I'm not recognizing it. So I'm sorry if this is the case. But in any event, from the point of view of a litigant, of a legal citizen, what matters is that the unconstitutional law is not applied in his or her case. Therefore, the ordinary court should take all the possible means to avoid unconstitutional or counter on non-compliant application of the law.
Дякую. Валентина Іванівна Денішевська.
Thank you very much. Valentina Dinishevska wanted to make a comment. Thank you, Miroslava. I wanted to reflect on this, on what Mr. Hradovenko said, that in our life and in our practices, there was a case when we seemed to make two contrary statements. I mean, Supreme Court and the Constitutional Court. I don't think so. We didn't have contrary statements. I think we were just solving different tasks, I mean, the Supreme and Constitutional Courts. But I must agree with you that maybe some lack of clarity or maybe even use of unnecessary arguments could produce this impression. The law on notaries identifies that it is possible to apply with a notary. It's possible 3 years for citizens and for within 1 year for legal entities, and then it reads unless any other prescription is defined by law. The Supreme Court received a case when we were requested to interpret these words. If any other prescription is not provided by the law. So the Supreme Court didn't even have the need. I mean, we just examined this issue and we gave the answer. I mean, period of prescription or limitation period, okay? So after the law on notaries was adopted, the civil code was amended in view of the need to ensure equality of the parties and the single period of limitation, the same period of limitation, the prescription was introduced for both natural persons and legal entities, and we stated that actually it's from the moment when this amendment was implemented. Since then, the legal entities also obtained this right to have these 3 years for applying with the notary, while the Constitutional Court was considering the point of constitutionality of the very fact of establishing different norms, different provisions for legal and natural persons. And Mr. Hrodovenko mentioned discrimination. Probably this impression was produced because the Supreme Court allegedly ignored this side, this aspect of discrimination. So maybe the discrimination did exist, had existed before at the level of the law, but later on this inequality was removed by the legislature after with adoption of new civil code. Many lawyers actually could not just understand what would be the right way to apply this provision, and the Supreme Court offered its interpretation. Of course, it's a pity that there was an impression as if our judgment was contrary to the judgment of the Constitutional Court. And when we received a similar case for our review, we certainly probably worded our decision better. And I don't think that now our views are contrary anymore. I started today my speech from our obligation to make sure that our views coincide so that we avoid to the maximal extent possible many situations when common courts actually have to test the constitutionality of the laws if there is another way to solve the case through interpretation of the law.
Якщо можна, тільки недовго.
Victor Valentinovich, you're given the right to respond. I will just take a minute. Given this opportunity and in the presence of our foreign partners who are helping us conduct this keynote international workshop, I would like to say that Valentina Ivanovna is 100% right, having set right my comparison, but the case law of the Supreme Court did apply the interpretation provided by the Constitutional Court, indicating that the constitutional and institutional dialogue between the Supreme Court and the Constitutional Court is always in place. I'd like to confirm that there is no discrepancy in the interpretation of the provisions of the Constitution or the law. If the Constitutional Court interprets the provisions of the Constitution, are always taken into consideration by the Supreme Court. And one more point I would like to make and thank Valentina yet again, that the means chosen by the Supreme Court for analyzing the discriminatory aspect was somewhat within the constitutional principle of equality, and this principle was interpreted by the Constitutional Court, and some aspects were not taken into consideration. So still, I'd like to thank Valentina and agree with her position. I would also say that the lawmakers had their say in this debate. I do recognize that the argument was excessive, but we didn't change our case law. We're consistent there, but the lawmakers also helped out and clarified the norm, stating that the term of limitation of appeals to the notaries for all the parties is equal 3 years. And this was the solution to the dilemma. Thank you. To continue the discussion, I'd like to ask Victor. I formulated a problem that the judges of the Supreme Court are pondering. So in your opinion, we've seen the trend before when the governmental agencies, for some reasons, would disregard the decisions of the Constitutional Court and would repeatedly enact some regulations that had previously been deemed unconstitutional by the Constitutional Court. So in your opinion, would you please give us your vision? Can the courts then, while the law is still in effect, even though it was enacted at a later stage, but similar provisions have already been deemed unconstitutional, can the judges apply a similar law? Ms. Miroslava, Vasil Vasilyevich was the keynote speaker on the matter, and I would rather refer the matter to him, and I would just add 2 personal touches, if I may. Then can we ask Vasily to give his response? If I understand the matter correctly, you're saying that the lawmaker complied with the decision of the Constitutional Court, having ignored his opinion. Can we conclude that the courts are free not to apply the law? Here we need to start by defining the criteria of constitutionality, and the criteria apart from the text of the Constitution, are enshrined in the statement of the Constitutional Court. And if the court believes that this provision is inconsistent with the Constitution, and there is a clear stance of the Constitutional Court on this matter, meaning that, in my opinion, we can say that this law and this provision is unconstitutional and does not need to be applied, triggering the procedure in place for repeat application. The thing is, we are noting a violation by the Parliament of its constitutional duty vested in it by the Constitutional Court to enact laws consistent with the constitutions and the decisions of the Constitutional Court on a legal dilemma. So I believe that would suffice to say that there are criteria for a law being unconstitutional. So what's the potential of any court decision? We keep joking that it gives clarity on a particular legal predicament. It gives greater legal certainty. And here, if we're talking about identical provisions compared to those already deemed unconstitutional, I would say this is enough for the General Court to state that this is the case. Thank you.
Я єдине хотів сказати.
Victor, the floor is yours. I would just add one touch and say that we may differ in our opinions about the Supreme Court and Constitutional Court are collective decision-making bodies, but what Vasily is saying, we fully support. And to follow up on this question, I will address a question to our international experts, our international colleagues. Fine. If a certain time, let's say 7 years, or let's say 10 years, elapsed after the decision of the Constitutional Court, so some time goes by, circumstances change, societal relations also change, and the judge always should be aware of the changing social circumstances. So when a lawmaker makes a similar provision, but with the passage of time, would the Constitutional Court take the same approach, or would the approach be different? Perhaps Mr. Broker or Mr. Norkus or George would like to speak on this question. You're welcome. Mr. Broker, you're welcome.
Yes, thank you very much for this question. And if you don't mind, I would change into my mother tongue, and my good friend Gennady Ryzhkov would help me, because I want to be very clear in this point, because it's a very important question. So,
Пане Ryzhkov, чи ви не заперечуєте підтримати зараз колегу?
Я не заперечую, єдине, що потім на англійську треба буде після мене перекладати, і я зможу перекладати тільки послідовно, бо я ж не перекладач і не в окремому цьому чаті. Але я послідовно переклав, звичайно, без проблем.
Тоді в мене прохання, добре, чудово. Тоді, якщо можна, з паузами, будь ласка, щоб всі почули. Дуже дякую.
So, die zentrale Frage ist, gibt es ein Verbot für den Gesetzgeber, ein identisches Gesetz wieder zu erlassen, wenn der Verfassungsgerichtshof das Gesetz bereits für verfassungswidrig erklärt hat?
So for the German doctrine, the central question is whether the lawmaker, again, even after a certain lapse of time, enact a law with an identical text that the Constitutional Court has already found to be unconstitutional.
Der erste Grundsatz ist, es gibt ein Normwiederholungsverbot. Es gibt ein Verbot, dass die Norm sofort wieder gleichlautend vom Gesetzgeber beschlossen wird, denn die Entscheidung des Verfassungsgerichtshofs bindet alle staatliche Gewalt, auch den Gesetzgeber.
The general principle applies that repeating the same text is forbidden for the lawmaker if the Constitutional Court has already made the relevant decision, since this decision is final and it is binding for everyone, including the legislators.
Das Gesetz ist schon deshalb verfassungswidrig, weil es dem Verfassungsgerichtshof den Gehorsam verweigert hat. Es muss nicht neu geprüft werden. Die alte Rechtsprechung gilt fort.
And
the next doctrine is that the new law, the new text, identical to the previous one, immediately by default is unconstitutional because the Constitutional Court has already spoken about a similar text being unconstitutional from the outset. It's acting unconstitutional, rendering the law unconstitutional.
Aber, und das ist wichtig, die Verfassung steht immer in ihrer Zeit. Sie ist organisch.
However, we need to say, and Miroslava, you have been saying so, that a long time has passed since, and the German doctrine states that the German constitution is also living in time, so it evolves organically.
Also muss der Gesetzgeber begründen, warum sind die äußeren Umstände so anders als damals? Warum ist es deshalb verfassungsrechtlich anders zu beurteilen? Und er muss sich damit auseinandersetzen, was das Verfassungsgericht gesagt hat.
And
therefore, this doctrine demands that after a long lapse of time, after many years, the legislators would enact a text. They can do it, but they should provide a justification and have a broad political discussion in Parliament why they feel in the time the elections and evolution of government have changed so drastically that they have to bring up the same issue again and have this right to regulate the social relations in this fashion. This position has to be well justified.
Denn Interpretation der Verfassung bedeutet ja immer das Konkretisieren der Verfassung. Wir werden immer enger durch die Rechtsprechung der Verfassungsgerichte.
As under the German doctrine, the interpretation of the Constitution starts with the existing relations of the time, but the interpretation and the Constitution live on, so the circumstances may change.
Thank you. D'accordo.
Mr. Ryzhkov, a support of Mr. Brock's ideas for the participants. If our international expert would also like to contribute to the answer provided by Mr. Brock, you are very much welcome to talk for yourself. Do you have anything to add? Would you like to add anything?
I would add just two sentences. Briefly, because it's a common issue, not just for one country, but generally for constitutional courts. It's very, very rare when the Constitutional Court overturns the case law. And not just constitutional courts, but if you look at the US Supreme Court also, they try to maneuver somehow about life, right to life or others. These cases are pending for 40, 30 years. And it's very rare when the court rules its decision, although made by other judges. But in Georgian case, it's never happened when the court said directly that I overturn the previous decision, because the court is very young, 25 years or something. And we didn't have such cases where like very substantial existential cases. But according to the procedure, when the case is related to the overturn of old provision, the case should be referred by the chambers to the plenum where all judges participate in order to make decision. But generally, there were cases when some judges think that the court decision on procedural issues was different from the practice, but it was not official position of the court. So they write sometimes the dissenting opinions or articles saying that the court changed the track, but it's not official position of the court. So it's a very sensitive case. Another source inspiration for other seminars and conferences to meet again.
If I also may add
Дякую, пан Норкус.
two aspects. First, as to the duty of the legislator to obey to the rulings of the Constitutional Court. It exists, absolutely. The legislator is not authorized to enact a new and unconstitutional provision of identical or similar content. Nevertheless, sometimes it happens. The question whether we should disregard this new legislation and deem it unconstitutional without a new application to the Constitutional Court, that would be one of the options. But in my point of view, for the sake of the cleanliness of the legal system, it would be better to eliminate it, not for a particular case, but just to show a signal that the unconstitutional laws do not have place in a legal system. And the second aspect, as for the possibility of the constitutional courts to show their approach, you are certainly very well aware from the jurisprudence of the European Court of Human Rights, as which has a little bit comparable abstract legal character as constitution, that convention is a living instrument, and I would say constitution is a living instrument too. The question how often we can change our interpretation is an open for the debate, but from the jurisprudence of the European Court of Human Rights, that court sometimes indicate that as things now stand, for example, as to same-sex marriages, there is no such guarantee in the current stand of the convention. But in the same ruling, the Court of Human Rights stated that it does not exclude evolutive approach in the future when, for instance, there is a larger consent between the member states of the Convention of Human Rights. Thank you.
Пані Мирослава, мікрофон включіть.
Мікрофон включіть.
Перепрошую, натискала не.
I'm so sorry. So we're over the time limit. Can I raise another question, if I may? So to continue on this question, and my question is addressed to everyone who responded to the question. Can the governmental agency ignore the provision of the law, or is it only for the courts when they address the disputes?
Хто хотів би відповісти? Можливо,
Who would like to give the answer? Yes, of course. I'd like Mr. Broker to comment on that, and maybe anybody else, because it's very important. What should the public authorities do? We understand courts, yes, okay. The situation is clear, but what about the state power? So, Mr. Broker, we certainly need your opinion with this respect too.
I'm not sure if I understand the question quite well. Just can you repeat?
Повторюю запитання.
Yes, I will certainly repeat it. So any provisions, imagine a provision of the law was declared non-constitutional by the Constitutional Court. 10 years later, legislators pass similar, absolutely similar text. And we already heard that this provision would automatically become non-constitutional. But for purposes of solving conflicts, the courts may make statements like that. But what about public authorities? Should they perceive this provision immediately as non-constitutional, or should they comply with it until the courts pass the respective decision?
Vielleicht eine Klarstellung vorweg. Ich möchte nochmal unterstreichen, was der Kollege Norkus gesagt hat zu der Frage, ist dieses neue, wiederholende Gesetz automatisch verfassungswidrig?
Ну, тут, напевно, знову я маю...
Here again, I probably need to get connected. Mr. Broker refers to ideas expressed by Mr. Norkus, whether this new provision is identical and hence non-constitutional.
Auch das neue Gesetz ist nicht automatisch außer Kraft, sondern es ist ein Gesetz und muss befolgt werden. Aber das Verfassungsgericht prüft nicht erneut in einem langen Prozess, ob es mit der Verfassung übereinstimmt, sondern sagt automatisch, ein Fall des Ungehorsams, deshalb verfassungswidrig. Aber die Verwaltung ist erstmal dran gebunden an dieses Gesetz.
Verfassungsgericht sagt automatisch, muss jemand sich doch an ihn wenden vorher, oder?
An das Verfassungsgericht, ja.
Можливо, я не зовсім
Maybe I was not exact sufficiently during my first speech when I said that this newly adopted law would become non-constitutional automatically. But on the other hand, somebody still needs to apply with the Constitutional Court, which in this case will not implement the full proceedings. They will just recognize it non-constitutional again if it's absolutely identical and the legislators failed to give any reasons why they decided to make it this way. This is what I meant by automatical recognition. Talking about your question on public authorities, according to German doctrine, until this automatic decision of Constitutional Court is made, the public authorities must comply. Because they might think that, unless the Constitutional Court, in this case, Constitutional Court will operate much quicker, of course.
Was kann ein Beamter tun? Was muss eine Behörde tun, wenn die sehen, dieses Gesetz ist verfassungswidrig, aber ich muss es anwenden?
If I may, I could go even further with your permission. What should an official do in such circumstances when he or she sees that the text is identical and probably non-constitutional? What do I do if I have doubts with regard to constitutionality of this newly adopted law?
Denn ein Beamter hat zunächst einmal gehorsam zu sein, das zu vollziehen, was das Gesetz sagt und sein Vorgesetzter sagt.
On one hand, an official is a public official and is supposed to comply with what was passed by the legislator, because so far this law is in force, is effective.
Aber hat auch geschworen, die Verfassung zu verteidigen.
On the other hand, according to German fundamental law, this official made an oath that he or she will comply with the Constitution.
Und deshalb kann nur seine Vorgesetzten informieren, darauf hinweisen, darum bitten, dass die aktiv werden. Aber ein Gesetz an die Seite legen kann die Verwaltung so nicht.
Then a smart official will do two things. He or she will comply with the law, but at the same time will inform in writing his or her management that he deems this law non-constitutional in view of the previous decision of the Constitutional Court, such demanding that his or her leadership or managers of this institution react by just filing an application with the Constitutional Court. Thank you. I see Slavica Banic wants the floor, please. It's yours.
Thank you very much. I greet you all. Just wanted to support all the comments of Mr. Brocker. And just to say that regarding the last question of Mr. Smokovic is that there is a presumption of constitutionality. And in our countries, which are having constitutional court, which is advised the competence of review the constitutionality, only then can be declared whether the law is constitutional or not. Because until then, our subjective presumptions, because of the existing decision or something that is wrong, they are not worth until the Constitutional Court says so. Regarding the previous question, which was about, which also was said by, commented by Mr. Brock, I just wanted shortly just to add that Constitutional Court of Croatia had a similar situation, you know, which we reviewed, you know, the old-fashioned law and the new circumstances. But I can also tell you that the Constitutional Court of Croatia made once a mistake in the constitutional complaint. We made a decision which after some time seemed wrong. And we actually had to heal the new coming situation. So we actually, in our decision, said that until now, we review the case in this manner, but from now on, we review it in another manner. We took the practice of the European Court on Human Rights, of course. So in order, you know, we reconciled, you know, the previous practice with the new coming practice. And the third last thing is that in Croatia, every citizen can initiate the constitutional proceedings. So to review whether a law or bylaw is constitutional or illegal. And the Constitutional Court can say, no, it's not unconstitutional, because the allegations did not advise that it could be unconstitutional. However, if another person sends another initiative saying that the law is unconstitutional from another aspect, then the same law can be reviewed and declared unconstitutional. So it means, you know, that we have the situation that the law can be reviewed 2-3 times, but if it depends how the initiative was made up, whether, you know, whether considering discrimination, whether any other aspect. And we reviewed it only from the aspect of, let's say, property, right property. And it was not, and the law was constitutional. However, from the aspect, let's say, from the right to home, it was unconstitutional. Thank you.
Дякую.
Пані Мирославо, з вашого
Thank you, Miroslav. Under your permission, just 2 minutes for me, please. I'd like to mention that we already have our jurisprudence and actual our experience of how we can find a way out of this solution. You might know that Ukrainian, maybe any other legislation sometimes has this sickness of doubling when you have the same provision in 2 different laws. And the Constitutional Court, based on an application, declared such provision non-constitutional in one law, while in the other law it still remained the same. So there was a question, how should this effective norm be treated in view of this judgment of the Constitutional Court that applied to absolutely similar provision, but in another law? So our chamber suggested the following approach. We actually referred to Convention on Human Rights, and we mentioned in our judgment that at that time there was confusing regulation which failed to meet criteria of the quality of the law, and we applied the law which is more beneficial for the individual. Thus, as we believe at least, we resolve the dispute for the benefit of the citizens and according to the judgment of the Constitutional Court, but we refrained from trying to declare certain provision non-constitutional because this specific provision of this law number 2 has never been had never been declared non-constitutional. So in this sensitive situation, one might want to look for any other ways to find the right decision without really commenting constitutionality. I will afford a very short question. I will have a short break. I'd like to hear also from our international experts first, then maybe Mr. Hrodovenko or anybody else would comment. What do we do in a situation where we have a specific case and there is an issue constitutionality? The court must conduct a check, and the Constitution does not have any respective provisions, as I mentioned in the law on civil service, for instance. There is no section on civil service in the Constitution, especially the competitive selection of potential civil servants. So what is the right way for the court to test the law on law's constitutionality in absence of clear provision in the Constitution? Is it important that this provision is clear and unambiguous? And unless it's clear, it may prevent a court from testing constitutionality and whether it would make sense at all to conduct such a test. Although today we certainly heard the opportunity to use the international law for this purpose, is there anybody from our international experts who would like to give answer to this question? Or did you understand the question, Mr. Norkus?
I'm very sorry. Perhaps someone else who had a better sound could take the floor and try to answer the question, because I'm not sure I grasped the essence of it. So I'm very sorry. Perhaps either you could repeat or someone else could try and answer.
Yes, if you don't mind, I will specify my question. What is the way for the courts to conduct tests of constitutionality of any legal provisions in case if there is no clear provision in the Constitution regulating this area of the law? For instance, for example, any points related to civil service. Let's take law on civil service. Constitution does not require, does not define any fundamentals of the civil service.
Thank you. If I understand the question correctly, there is no specific provision in Constitution governing a certain area of law, but the Administrative Cassational Court is confronted with a legal issue. First, as Constitution, Convention, or any other legal act of this abstract nature as interpreted, it has no legal gaps. It is an act of systemic and coherent interpretation. Even if there is nothing governing civil service, the Constitution can be interpreted in the light of general provisions governing the right of private life, the right of access to the court, the right to access to working place, different provisions which can be interpreted also for the sake of public servants. So in the case of absence of any general provisions, all the constitutions are governed by the rule of law, which is also a test let's say the last stage of the test to be applied if there is nothing more specific. So the Constitutional Court of Lithuania ruled on numerous occasions that there are no legal gaps in constitution, and every act, irrespective of his nature, of his content, can be checked on its constitutionality. My answer is very simple. If you have doubts about the constitutionality, you need to substantiate them in the light of the general provisions of the Constitution and put the question forward to the Constitutional Court.
Дякую. Наші міжнародні колеги, хтось хоче ще щось?
Thank you. Maybe anybody else from international colleagues? Slavica Vanic, please. Yes, the floor is yours.
Just to add this, what Mr. Horkus said, you know, that we also had the occasions we didn't have the specific provision, but then we really relied on rule of law, first of all. And then also we rely on international documents. Then we call it as a kind of help, you know, because, for example, regarding the civil service issues, even in Ukraine, the international treaties like the International Declaration on Human Rights for Political Rights, they refer to civil service as far as I remember. So we are actually entitled to call into help these international treaties, and Constitutional Court did it many, many times in that regard, you know. But of course, we always found kind of a provision which we could rely from our Constitution. And if nothing appeared, it was the rule of law principle. Thank you.
Дякую. Хтось ще, пан Брокер, хоче щось сказати?
Thank you. Maybe Mr. Broker would like to add a few words. Mr. Pushvili, are you with us?
На заході, так?
Well, he's at another event. Okay, so since international experts have expressed their opinion, yeah, I see Mr. Lemma wants to say a few words. See, this is what I think about it. Your question was, can it be the case that Constitution does not contain clear provision? In my presentation, this is what I tried to say. This is exactly what happens most often. Even if you have a text that the Constitution is very rarely written clearly and specifically. Normally, it's just absent. But the colleagues emphasize that the Constitution should be perceived as a document without any gaps and loopholes. But let me get back to the first part of your question. What I believe is that a judge of common court is not supposed to check constitutionality in advance. The task is to solve a legal dispute. That's the key. The task is not to check whether the law is constitutional, but to apply correctly a constitution, the law, etc. So if a judge gets to the point when he or she is missing regulations, this might happen, but very rarely. It's hard to give specific answer to your question, but the colleagues stated very clearly that you need to proceed from the rights that are explicitly expressed in other documents. You need to go to the constitutional principles. And as you noticed correctly, in fact, we have parallel system of constitutional law, which are international treaties on human rights. In fact, this is European constitutional law. So it's very rarely when you have a situation where the judge is absolutely frustrated because they cannot find a solution. The judge should not be programmed to check, first of all, the constitutionality. The judge should be programmed to find a solution to a legal dispute, being guided by the legal norms and principles of the law, including application by analogy, That's Mr. Hrodovenko. Yes, just 2 words. I just wanted to say that the latest practices of Constitutional Court for the last 2 or 3 years fully coincides with what Slavica Banic said. And of course, yes, Vasily Vasilyevich mentioned that we use methodologies of European Court of Human Rights were based on the principle of the rule of law. Thank you, dear colleagues. Now we must conclude our first part. I apologize for delays. So what are we taking away? First, the application of the Constitution as an act of direct effect should not contribute to arbitrary decisions of courts or public authorities. Test for constitutionality should be done in a way which is closest to the Constitution, until there is, to the extent maximum action possible, and unless the law has been declared unconstitutional, it's still effective. And in order to test the level of fairness as presented in the constitutional law, they should apply the approach used by the Grand Chamber and mentioned by Mr. Broker, the approach which is the most favorable to the individual. I suggest that we make a very short break of 10 minutes. Thanks to our colleagues from the Constitutional Court. I know you have another event. Also, very thankful to our international experts, who certainly are waiting for further continuation of discussion. Thank you, colleagues from the Constitutional Court, the international experts. We have 10 minutes and then we are back here. Thank you.
Шановні колеги, технічна підтримка. Нам потрібна допомога з пані Ганни Христової презентації. Напевно, два паралельних екрани не може бути, так?
Так, колеги, шановні учасники нашого заходу, під'єднуємо.
Dear colleagues, dear participants, let's be getting on our way. We'll continue.
Я не бачу поки що наших колег. Ага, бачу.
I'm still waiting for our colleagues to join us. So I believe we can be getting started and others will join us. So now we transition to the second session, which is called the non-compliance of the law or legal act with the Constitution, the interaction of the administrative courts and the constitutional courts when the constitutional court finds a law or another legal act unconstitutional. I will only make a few remarks at the beginning that we have already covered in the first section, that the Constitution provides the presumption of constitutionality of the law, and we interpret the laws in favor of the Constitution. And when a law is found to be unconstitutional, which is the subject of the second session, I would suggest we cover the criteria that an administrative court may use to justify that a certain law is unconstitutional. Some of them have already been formulated by the Supreme Court. We also find sources in the European law and higher courts, and it's about taking a creative approach. And what are some other key considerations that the court should take? That's Article 129, which was recently edited in 2016, which stated that the judge is independent and governed by the rule of law, allowing the judge to apply the creative approach by applying different methods and approaches to interpreting the law and making use of the norms of the Constitution, which are primary in the application of the law, but also some additional methods stated by Mr. Lerman being the norms of the international law. So let's talk about the writs of the law, the standards that the administrative judges can follow when they consider the laws reviewing the case for being constitutional, and about the duty of the administrative court to apply to the constitutional court whether that norm is imperative and what kind of form it is, whether it is an intermediary control mentioned by Mr. Horodomenko, referring to Mr. Yezerov, whether it's a function of oversight. So these are matters for us to discuss. I'm giving the floor to Mikhail Ivanovich Smakovich, the president of the Cassation Administrative Court, part of the Supreme Court, who will talk about the non-compliance of the law or legal act with the Constitution and how the administrative judge should handle such cases. You're given 20 minutes, Mr. Mikhailo. Thank you. Good day to everyone. I may have missed someone when I was doing the welcoming remarks. So the application of the law for adjudicating administrative cases is a relevant one. It is very good that we are seeing this vast wealth of opinions, and we'll apply these opinions and recommendations as we solve the disputes presented to us. As for the topic I've been given, it would be challenging to give a detailed representation of the challenges, but let me cover some key challenges. Thus, in 2017, the Верховна Рада of Ukraine made a number of fundamental changes to the procedural code, and same year, the Code of Administrative Justice of Ukraine was amended with a number of key provisions and additions. If I could have the second slide, please. So, among other things, the changes were made to Article 7 of the Administrative Code of Ukraine, which determined the sources of law to be applied by the court in handling an administrative case. Administrative case is just a dispute of a public law that is referred to an administrative court. The administrative court is obliged to decide court cases pending before it in accordance with the provisions of the Constitution and the laws of Ukraine. So the Constitution of Ukraine contains an imperative requirement, namely that the governmental agencies and local self-governance, their officials are obliged to act only on the basis within the powers and in the manner prescribed by the Constitution and the laws of Ukraine. Thus, in Ukraine, the principle of legality is an integral part of the functional activity of every governmental agency, including administrative courts. However, the practice of national and foreign lawmaking indicates that the principle of legality, in contrast to the principle of rule of law, does not always have justice as its denominator. Laws can also be unfair. They may contradict the requirements of the Constitution. In such circumstances, the practical implementation of the unjust laws in a state should be impossible and illegal. Otherwise, this state could not be considered one with the rule of law. Given the Constitution of Ukraine, providing that it is a democratic state with the rule of law, it would be perfectly logical to consider the Part 3 of Article 7 of the Code of Ukraine, saying that if a legal act is inconsistent with the Constitution of Ukraine, a law of Ukraine, an international agreement ratified by the Верховна Рада of Ukraine, or another legal act, the court shall apply a legal act having higher legal force or provisions of the relevant international treaty undersigned by Ukraine. Importantly, the legislators didn't stop there, and in Part 4 of the same article of the Code of Administrative Justice of Ukraine regulated some very important key provisions. Thus, if a court concludes that a law or another legal act contradicts the Constitution, the court shall not apply such law or legal act, but shall instead apply the norms of the Constitution as the norm of direct effect. This proves that the architectonics of resolving cases by administrative court is a most challenging task with many major semantic and legal data, which requires the court to comprehensively study the case and develop insight into the case. Therefore, considering the legal regulation of administrative proceedings, which are generally meant to ensure fair, impartial, and timely resolution of disputes in the field of public relations, for the effective protection of rights, freedom, and interests of individuals, and rights and interests of the legal entities, protecting them from violations of the agents of power, I consider it necessary to focus on the following key aspects. Firstly, the normative approach of the legislator regarding the powers of the court, choosing not to apply the law if it concludes that it contradicts the Constitution and apply the norms of the Constitution instead, is clear, and it perfectly logically corresponds to the principle of the rule of law, a ascending element of which is justice. And it also agrees with a number of other imperative requirements of the Constitution of Ukraine, namely that the laws and other normative acts are adopted on the basis of the Constitution of Ukraine and must comply with it. Appeal to the court to protect constitutional human rights and freedoms directly on the basis of the Constitution is guaranteed. Therefore, the architectonics of the meaningful provisions of Article 7 of the Code of Ukraine is permitting the administrative court to identify the errors of the legislators or other lawmakers when adopting relevant legal acts. Secondly, let's have the seventh slide. If I could have the secondly, the judges should consider that the norms of the law cannot be applied automatically, if only for the reason that they are valid, they've been enacted. The thing is, the effective law is only a prerequisite to its effectiveness. The governmental agencies have to take steps to implement and enforce the law, like bring other laws and regulations in compliance with the current law, inform the law, enforce the regulations, etc. Otherwise, the law would have no legal force. So the judges, in my opinion, are the very representatives of the government, which are bound through the critical analysis perceive any law, including the law as demanded by the Constitution, as demanded by the society, which has to live within certain legal limits enacted by certain representatives of the government or self-governance. So the critical review of the law for its consistency with the Constitution of Ukraine should be prior to the practical application of the law. So that should be an integral part of the administration of justice. That's on the one hand, but on the second hand, we should pose ourselves the question, what would it mean when the courts apply the provisions of a law or a legal act without assessing it for consistency with the Constitution? The superficial answer would be that it would be a violation of the requirements of the administrative code. It would also undermine the imperative requirements of the Constitution. So the judges should read the Code of Administrative Justice not as a right, but as a duty. Thirdly, the content of legal regulation stated in the code defines the powers of the code as it hears administrative cases, as it makes possible a direct application of the provisions of the Constitution, and the court deciding not to apply the law if there are grounds to believe that the law in question is unconstitutional. Moreover, the lawmakers, should the court identify the error, would urge the court to speak out against the non-compliance of the law, but take the procedural steps to eliminate the inconsistencies. The judges have to be aware that when they take these procedural steps, they are acting on necessity. Indeed, consistency of the laws and the Constitution would create a solid legal platform so that the operation of the lawmaking and law applying agencies of the state would be done consistently with the rule of law and the Constitution of Ukraine and the exercise of their practical powers as stated by the Constitutional Court of Ukraine in its decision would be done within the limits set by the main law of Ukraine. And ensuring consistency of the case law would be the exercise of the principle of legal sanctity, which is one of the fundamental prerequisites for the rule of law, guaranteeing reasonable expectation of the court decision. At the same time, the consistency of the case law would also ensure the principle of equality of all people before the law, expressed by uniform application of the law in similar cases pertaining to different persons. So the consistent legal basis regulating the relations in a country would yield the consistent application of the law, and that is important prerequisite for the operation of a legal state. And also refusing to consider review the law for its constitutionality should be considered as an unmotivated decision made by the court. This decision of the court would not be consistent with the goal of administrative justice in Ukraine, as under the Code of Administrative Justice, the decision of the court should be vested on the grounds of the rule of law, be legal and justified. A decision approved by the court under the substantive law, procedural law, and it's justified if the court made the decision based on the full and comprehensive review of the facts of the case, supported by evidence examined during trial, with the assessment and arguments presented to the parties of the case. Refusing to review the law for its compliance with the Constitution, if the claim is properly justified, would be a violation of the principles of fair trial, which gives rise to the appeal of this decision to the European Court of Human Rights. European Court of Human Rights, in the decision of 1999, in a case, Marescu versus Romania, underscored that the right to fair trial is guaranteed by point 1 of the Article 6 of the Convention on the Human Rights and Fundamental Freedoms. It should be interpreted in the context of preamble to the Convention, stating the rule of law as a constituent part of the treaty relations between the parties. And another important point to be made is the clear understanding of the content of the legal norm of Article 7 of the Code of Administrative Justice, in the part which means non-compliance of the law with the Constitution. Here we need to consider the difference between the competence of the Supreme Court and the Constitutional Court of Ukraine. The theory and practice of the law denotes legality, constitutionality of a legal act. They are not the same in their content and legal consequences. The resolution of the issue about the legality of the act is the competence of the administrative act, while the law being constitutional definitely belongs to the competence of the Constitutional Court. Indeed, the norms of the Ukrainian Constitution clearly define the limits of the jurisdiction of the Constitutional Court based on the following principle, that all the matters that under the Constitution belong to the jurisdiction of the Constitutional Court cannot belong to the competence of any other body, including the Administrative Court. Also, the lawmakers have regulated a very important imperative. That the jurisdiction of Administrative Court does not apply to the cases that pertain to the jurisdiction of the Constitutional Court. And that's yet another distinction between the two jurisdictions. The Administrative Courts could make the following types of the decisions: to find the regulation illegal or some of its provisions, rescind some of its provisions or the entire law,
Contradiction of a law to the Constitution of Ukraine defines its unlawfulness, meaning that there are legal grounds for any effect of this act, and shows that such a law would not produce any legal effects for any legal relations. So the case law shows that it is possible the situation when a law believes that a certain legal act cannot be followed because it counters the Constitution of Ukraine, but on the other hand, any judgments are binding, and the judges must make necessary steps to solve a certain legal dispute. So we move to another aspect of this presentation, where I stressed that the legislature induces the court not to disregard lack of constitutionality of any legal act and to make any steps required to test their constitutionality, which means that a court that concluded that certain law counters the Constitution should apply with the Constitutional Court in order so that the Constitutional Court checks the constitutionality of the specific provision. So now, next slide, please, number 17. I would note that the Constitutional Court of Ukraine, according to Article 150 of the Constitution of Ukraine, would solve the issue of constitutionality of the legislation or any acts issued by any public authorities of Ukraine by request of the Supreme Court of Ukraine, including official interpretation of the Constitution of Ukraine. So the Supreme Court is the only body within the judicial system of Ukraine which has exclusive right among all other judicial bodies to apply with the Constitutional Court with this specific request, which means that the Supreme Court is expected to make very thoughtful decisions in these matters, while the lower instances courts have full right to expect from the Constitutional Court the proper solution of their issues. Thus, these relations between the Supreme Court and lower courts meets the principle of legal certainty, because it is an indicator of that the proper legal steps will be implemented. And here it also includes whether any constitutional provisions should be applied to administrative cases. whether this can be done by the administrative courts, lower administrative courts, in particular, the justices of the constitutional courts mentioned that, but didn't really make a full statement with this regard that we need to clearly understand what an act of direct effect is, because activities of constitutional courts are bound by the law. It is supposed to act according to the constitution of Ukraine, although Judge Lemak noticed that not all the constitutional provisions are acts of direct effect. That's certainly common for us, judges who apply constitution, and we already have many points to think about. If due to objective reasons, the court cannot apply specific law, it is supposed to apply the constitutional provisions that should have direct effect. Now, slide number 18. I believe that most of the constitutional provisions have general declarative character. They are not specified, they are not specific. It certainly complicates its direct application, but of course, for purposes of the decision of certain administrative case, solution of certain administrative case, because using the Constitution as act of direct effect, it might not really regulate some specific legal relations or protect some specific rights. Now there is very active discussion. It's not only among the scholars, but also among the community of practitioners. I don't want to get into the discussion now. Maybe later on when we conclude by its content. Articles 46 and 130 of the constitutions are specific enough, which allow administrative courts using constitution as act of direct effect. But I need to note that the constitutional provisions cannot be really fully specific. So here I believe where the constitutional provisions lack specificity and fail to regulate specific concrete problems, then the question of the compliance of specific legal act with the Constitution of Ukraine should be checked by the Constitutional Court. So we have well-established case law disregard where the Supreme Court plays an important role because we do have such mechanisms. Indeed, the Supreme Court, among others, has to consider disputes which has decisive role for the society and the state. So slide number 19. So, the mission of the Supreme Court as the high judicial instance in Ukraine consists in the need to form the well-grounded, unique legal positions compulsory for all lower courts, thus actually shaping out the single and consistent case law. We should take examples of specific cases to explain the approach to interpretation of these or other parts of the legislation without certainly imposing the results of our judgments over onto the lower administrative courts. By the way, many courts, not only administrative courts, but courts of other jurisdictions, had to deal with such problems in their activities. I am talking about repetition, adoption by the Parliament of Ukraine of the laws which repeat those which were declared non-constitutional by the Constitutional Court before. The legislative practice show that these cases are many, unfortunately, but the Constitutional Court of Ukraine warned about these problems many times, especially this concerns the pensions, social benefits for the citizens of Ukraine, because they are continuously changed by newly adopted laws of Ukraine, thus changing the basic provisions of the laws that regulate these relations. So here we can see that the legislator fails to react to any opinions of the Constitutional Court. And if you look at the years like 2007, 2008, in spite of any judgments of the Constitutional Court, they still would pass laws identical to the laws that had been declared non-constitutional before. So the Constitutional Court has to do this job once again. With this respect, the judgment as of 2016, number 4, RP 2016, the Constitutional Court stated that the laws are the legal acts or the separate provisions declared non-constitutional may not be adopted in the similar version because the judgments of constitutional courts of the Court of Ukraine are binding and shall be executed on the territory of Ukraine and cannot be appealed. The repetitive implementation of the legal regulations declared non-constitutional gives ground to identify violation of the constitutional provisions, according to which laws and other legal acts shall be based on the Constitution of Ukraine and shall meet its provisions. So this is also judgment of Constitutional Court, but I will ask the question to what extent the common courts may use it, because we are talking about the identical provisions. Here we have a number of questions. What should be the format of procedural steps to be implemented by the common court? Should they apply constitution as an act of the direct effect, or should they apply the provisions of the respective special law, or should they address the constitutional court? The list of issues that I've mentioned can be continued, but this low quality of opinions of the Constitutional Court and of the decisions of the Parliament has very negative impact over the case law of Ukrainian courts. I'd like to say that this does not induce the formation of the proper legislation. So any challenges need to be met in systemic manner, and this is what actually the Supreme Court has been trying to do during our activities. Now, the slide number 22. Hence, the substantial consistence of the legal platform to regulate social relations in the state are very important, because it fosters formations of the consistency of the case law, which is a condition, important condition of functioning of the democratic state based on law. That's all I have. Thank you for your attention. Thank you. Mihailo Ivanovich, esteemed participants, I really apologize for some technical shortcomings with the slideshow, but let me assure you that the full text of this presentation will be available on the site of the Supreme Court, so you'll have all necessary opportunities to become familiar with them, I'd like to tell you that we ask for some prolongation of our time, but we need interpreters. So we apologize, we had to extend some time, but actually time of our interpreters is limited. So we will appreciate if you can be brief. So now our colleague Vyacheslav Klak will talk about the relations between Supreme Constitutional Court. Thank you very much. First of all, let me express my respect
вже за висловлені позиції,
to the
міркування.
organizers of this event, to the hosts, to all participants, and in view of the last comment by Miroslava, I will very briefly mention some aspects of application by Cassation Administrative Court of the Supreme Court of the constitutional provisions as acts of direct effect for purposes of dispute resolution. So first of all, I'd like to note that actually the fact of application of by our court of the constitutional provisions as act of direct effect is important for purposes of consistency of the case law and to ensure the legal certainty as basic principles of the rule of law. The legal framework is placed in the fundamental law, which is that constitutional provisions have direct effect, which means that any citizen is guaranteed the right to complaint on the basis of the constitutional provisions. Then it was implemented through the Code of Administrative Justice of Ukraine, in particular parts 1 to 4 of Article 7 of this code, and we've already discussed their provisions number of times, and esteemed colleagues mentioned that already several times. I will not repeat them. If we analyze the case law, when the Cassation Administrative Court applied constitutional provisions as acts of direct effect for purpose of dispute resolution, I'd like to actually define separate groups of the cases where the court formulated legal conclusions with this respect. I'd like to note right away that I'm talking about kind of a classification, but since it's very conventional, it's rather grouping than classification. So we had the following groups. First, the cases on declaring invalid a legal act adopted without following the procedure of its publication. Second group, the cases on declaring unlawful acts or omissions of a controlling authority during inspections. The third group of cases are cases on application of financial sanctions to the taxpayers for any breaches of their tax obligations, and also cases on application of financial sanctions for improper tax return statements. So group number one, in particular, when the cases are considered on declaring invalid any legal act which was adopted with violation of proper requirements for promulgation. Our court actually formed a legal opinion by which decisions of local self-government to establish a local tax without proper promulgation is a violation because the tax code of Ukraine is to be applied in the light of the Constitution of Ukraine, and actually any citizen is guaranteed the right to challenge such decision based on the Constitution of Ukraine. So local councils, for example, decided to set a tax for the real estate property, and the court decided that such decision shall be published before 15th July. I mean, that's beginning of the quarter, since this decision will apply. Otherwise, the provisions of respective decisions will be become applicable only after the beginning of the respective period. Talking about the rules of collecting tax on real estate should not be the grounds for collecting this tax based on decision of the local council, because the Parliament of Ukraine, according to the tax code of Ukraine, also establishes the list of local taxes and levies pertaining to competence of local councils. They should follow the law. In view of that, our courts held that the provisions of the tax code of Ukraine must be applied in accordance with the provisions of the constitutions of Ukraine of the effect. In particular, Article 57 guarantees to everybody the right to know his or her rights and duties. And such rights and duties shall be brought to the notice of the public as per procedure established by the law. If this procedure has not been followed, so respective information was not delivered to the citizen, then such decisions are invalid, which means that the Article 57 of the Constitution, in fact, makes it necessary to declare invalid any legal act adopted without following the proper procedure of its promulgation. Article 64 of the Constitution reads that the rights of such citizens cannot be restricted even in conditions of the state of war or emergency. Talking about the second group of category of the cases, so when considering cases on declaring unlawful activities of any authority during their inspections, our court applies provisions of Article 19 of the Constitution of Ukraine, by which public authorities and local self-governments and their officials must act within the limits of their powers and in the way as provided by constitutional laws of Ukraine. A short example, based on application of this constitutional provision as act of direct effect, and also based on Article 75 of the tax code of Ukraine, by which the controlling authorities or inspecting authorities are not allowed to conduct unscheduled on-site inspections if such inspections on the specific subject matter have already been conducted within the specific period of time, or say Article 94 of the tax code, which defines procedure to apply administrative sequestration of a property of a taxpayer in order to secure compliance with their tax obligations, also provides that such sequestration is applicable only if such taxpayer refuses to be subject to the respective inspection or refuses to grant access to the representatives of the tax authority to their facilities. And in this case, the duty of taxpayer to give to the inspecting authority access to the facility shall apply provided there all preconditions for such purpose are met. Thus, the Supreme Court again relies on provisions of Article 19 of the Constitution of Ukraine and on the principle mentioned before, according to which public authorities and local self-government are supposed to operate exclusively in the way and in the manner and within the limits of their powers.
If we consider imposing financial actions for failing to submit reports, like the control operations report for the reporting period, the Cassation Admin Court within the Supreme Court has stated that under Article 58 of the Ukrainian Constitution, the law and other regulations do not have retrospective effect except when they mitigate or lift the liability. No one can be accountable for the deeds which at the time when they were committed were not considered a crime. In this case, the Supreme Court considers the decisions of the Constitutional Court of Ukraine, in particular the decision as of 9th of February 1999. And as a way to wrap up, I would just like to say when hearing tax disputes, the Cassation Admin Court of the Supreme Court has expostulated the importance of applying the provisions of Constitution of Ukraine, which directly guarantee protection for the taxpayers of their rights and interests. In particular, such right is enshrined in Article 55 of the Constitution, and its provisions have the direct effect. But we should emphasize that the Cassation Administrative Court has made a legal conclusion under which the constitutional right of the person to apply to court corresponds with his duty to abide by the procedural requirements set forth in the law. So the legal protection of the court can be granted on condition there is a violation made by the governmental agency of the rights and freedoms of the complainant, and the violation has to be real, pertain to the individual rights and freedoms of the individual who asserts that the violation has taken place. So the application of the provisions of the Constitution by the Cassation Court is a direct application of the Constitution, is effective way to uphold the protection of the rights and freedoms of the taxpayers. Thank you very much for your attention, and I hope I made it into the allocated time. Thank you very much. Thank you for your presentation. It's very insightful, very thorough. You've given some different types of cases. You've given us your analysis. It's been very helpful for us to hear your insights. I'd like to give the floor to my colleague, leaving some time for question and answer session. And I'd like to give the floor to Mr. Yezerov, who is going to talk about the procedural aspects and the application of the constitutional provisions. Thank you. Good day, everyone. I too was thinking that we're holding this event dedicated to the topic I've been trying to promote recently. And in response to the previous presenter, I'd like to highlight our understanding of the legal institutes and mechanism. And I feel it's very important to discuss the question, make conclusions, and then apply them in practice. When we talk about the content of the institution, I would like to focus on the procedure instead. And I will raise more questions that I will be able to provide the answers to. So the current institutional design for the supremacy of the Constitution calls for the interaction of the courts of all levels, down to the plenum of the Supreme Court, and interaction between the Constitutional and Supreme Court. A lot has been said about the collaboration between the Constitutional and Supreme Court, but I would like to focus on the collaboration of the general courts with the Supreme Court. When the courts of general jurisdiction administer justice, they have to look into the spirit of the law and its consistency with the Constitution. And in all needed cases, they should refer to the Constitution as the supreme law. This should not be perceived as a violation of the exclusive jurisdiction of the Constitutional Court. Instead, it's the functional relation between the different courts of different instances in order to protect the rights and freedoms on the grounds of the Constitution. And this has become possible as the result of the procedural reform, which enshrined this right with the general jurisdiction rights, but did not, however, formulate the procedure. But the practice of applying these provisions isn't vast, but it has already shed light on a number of problems that call for resolution. The procedural codes about the subjects and the general rule, but there is no step-by-step manual for us that we could follow. It's perceived that it will be born out of practice of application of the law, and this case law has to be consistent. Very importantly, the court decisions have to be well justified, well motivated. And if they refer to the Constitution as a direct effect norm, this justification becomes even more demanding. If a court refuses to apply a law, it has to justify this decision, and just general reference isn't enough. This reasoning will be then reviewed by the high-level courts, and the plenum of the Supreme Court should also consider this when it decides to accept a case for review or to refer it to the Constitutional Court. The reasoning of the court should be given scrutiny. And I noted a phrase from Mihail's presentation that administrative courts of lower instances can expect an objective, motivated decisions about its application from the Supreme Court. And indeed, the courts that have been turned down about the plenum, about their reference to the Constitutional Court, are expecting to see a reasoning, a justification for their application being turned down, why the first instance or second appellate court was not supported. And I know that the judges expect an answer and expect an explanation from the plenum of the Supreme Court. As to the form of application to the Supreme Court about the direct application of the Constitution, this is also a controversial matter. Either the courts choose not to apply to the plenum or do so through their reasoning in their judgment, or as a separate opinion or a separate letter. So in practice, the methods vary. When a court considers a model case or landmark case, it referred to the resolution of the plenum of the Supreme Court, and this is the right approach. But the Grand Chamber, acting in this case as the second instance court, changed the reasoning in the decision, stating that activating this direct application of the Constitution shouldn't be resorted to. But the decision of the Cassation Court is still in effect, so should it be subject to review and should it be referred further to Constitutional Court or not? Moreover, the questions arise: what subject should have the right to admit such applications. They're currently done by the Secretariat of the Supreme Court, but this application has to be drafted by the initiating court. It's also felt that it has to be done by the Supreme Court judges through a working group in the plenum. Considering the applications of the court, the plenum should decide whether submit this application to the Constitutional Court or turn it down, but there are no clear criteria for making such decision yet. It's perceived that when these criteria will be developed, they will render greater legitimacy to the procedure. There's no consistent approach about the limitations of the appellate and cassation reviews and whether the plenum decision would affect such review. These procedures are not mutually dependent, but the cases are not reviewed by the plenum before the decision in the case becomes final and comes into effect. The court refuses to apply the constitutional provision, and this has to be stipulated by the procedural requirement and application to the Supreme Court about the constitutionality. And this calls for an effective review of such applications, a very thorough analysis of each application, and very consistent and very logical exercise of its function when it refers the cases to the Constitutional Court. Thank you for your attention, Albert. Thank you very much. Thank you for being succinct. Thank you for being succinct as we are pressed for time. And I do hope that it's been nevertheless very useful. I'm giving the floor to Slavica Banic, the president of the Constitutional Court of Slovakia. She's a member of the European Committee, Democracy Through Law, and she will talk about the constitutional protection of individuals who suffered from armed conflict and internal displacement, giving us the Balkan experience. She will talk about her experience of protecting the rights of the people in very difficult environments. Thank you. The floor is yours.
Thank you very much, Madam Bilkov. Dear colleagues, I greet you once again from Zagreb, and I thank to the COE project on internal displaced persons to invited me again here, and I really feel honored and interested to be a part of this important event. It was not very easy to prepare this presentation because I read your constitution over and over and compared it to the constitutions from the countries of former Yugoslavia, which were in my consideration for presentation. But at the end, it seems like we do not have so many differences as we have language approaches, different language approaches to certain issues. I wish to remind you, in general said actually what our moderator introduced me to, that last year I touched upon the relationship of the legal rights versus constitutional rights. And I realized that this issue is relevant on this topic as well. So I hope that we will have a chance to speak again about this correlation between legal rights and constitutional rights. So the coherent and harmonized constitutional order, the one that is desired actually by Ukrainian constitution or Croatian or Serbian constitution or German constitution, puts us in front of the question how to accomplish such order. So how should be their approach to constitution? Our former societies, socialist societies, approach to it as a pure political act. Now we have the idea that it is a normative act, but actually, how should we understand it, and how much then the constitution can stretch, said in simple words. So this question is very important for the administrative justice. Why? Because it is exactly the place where the rule of law principle, with all its elements, legal principle of legality, human rights protection, prohibition of arbitrariness, legal certainty, the access to the impartial court and judicial review against the administrative decisions comes into question. This is also the place actually where the best is kind of confronted, actually measured the power between the rights of the individual and constitutional limits of public bodies when deciding in individual cases, or margin of appreciation on the side of the state to limit the individual rights. Therefore, majority of European constitutions, like yours and Croatian or Serbian, include actually the provisions on judicial protection against the decisions or actions of the administrative bodies. Next slide, please. Okay, so in this slide, actually, I wanted to show you how in the constitutions on Western Balkan countries is regulated the issue of administrative justice. As you can see in the Republic of Croatia, actually, it is done through the guarantee, through the principle of legality against the decisions of state administration. And if you see this Article 19, the paragraph 2 says that judicial review of individual acts made by administrative authorities is guaranteed, and this is considered as constitutional right of every citizen, that he or she has the constitutional right that his administrative act is reviewed by the judiciary. In Republic Serbia, it is a little bit differently said, but in essence, actually, it is almost the same. It says also that the legality will be reviewed and that the administrative dispute will be allowed against these decisions. Bosnia and Herzegovina is a little bit different because of complex organization of this country. It has two entities, and these two entities have own constitutions and differently approach to the issue of administrative justice. So one entity does not have any provisions on it, while the other entity, which is called Republic Srpska, reflects the provisions which are made in Republic of Serbia. And last but not least, Montenegro is very simple. It says the same, that the final individual legal acts enjoy the judicial protection. So next slide, please. Almost all of these countries, as you can see, and I will repeat myself maybe from the last year, have suffered directly because of consequences of war. Only Montenegro did not have direct effects of the war but it was included in Yugoslavia during the war against Croatia and Bosnia and Herzegovina. But actually, these three countries, Croatia, Serbia, and Bosnia and Herzegovina, suffered very much in regard to the issue of refugees and displaced persons. And they made a body of legislation with in regard to this. As you can see, I show you actually what kind of legislation Republic of Croatia made with regard to displaced persons. And all of this legislation actually tells you that this belongs to the public law area. So all of these laws actually were the subject of the administrative decisions by administrative bodies, and further on, they were reviewed in judicial review by the administrative courts. All of these countries, if you will see, for example, just to make a practical digression, you have here the law on reconstruction from 1996, and it allowed actually displaced persons right to return home, to reconstruct their houses, etc., etc., etc. And what happened with regard to this case, actually that the citizens who had, so the state allowed reconstruction of the homes on the territory that were previously occupied. But suddenly, actually, some of these parts were some of these houses were made as summer houses, as actually houses for resting. And there were several citizens actually who claimed inequality because their houses on these territories could not be reconstructed, because the law said actually that only the houses for living for people who wanted to return and to reside over there could be reconstructed. The Constitutional Court actually said that it is constitutional because it is not actually that the state was obliged to do this in regard, to equalize all citizens. It could actually make the difference, and the object of the protection was actually to revive these regions, to enable people to return back to live over there and to earn their living in these regions, not to enjoy summer houses as it is. So next slide, please. I'm trying to be quick. So as I have said, all these countries actually inherited the law on general administrative procedure from former Yugoslavia. Yugoslavia was one of the rare socialist countries that had the general administrative law, general act on general administrative procedure, that is how it's called, and the law on administrative disputes. So it has a long tradition on protection, on judicial protection of the individual acts made by the administrative bodies. So all of them actually have very similar solutions even today, because they rely very much on these laws made back in 50s and later on in 70s. Could you just change this? Okay, the effect of the constitutional provisions in administrative justice in these countries derive not only from these provisions from the constitutions that I showed you, that actually guarantee the judicial protection against the administrative acts, but actually from the whole constitution. And the Constitutional Court of Croatia, relying on the German actually case law in that regard, of the Constitutional Court of Germany in that regard, said the following: the Constitution makes the unified whole. It cannot be approached in a way that from the entirety of relations that are regulated, one provision is taken out and interpreted separately and mechanically, regardless of all other constitutionally protected values. The Constitution possesses the internal unity, so the meaning of the single part is connected to all other fundamental decisions, in connection of which must be interpreted all its individual provisions. The Constitutional Court of Croatia is quite severe toward administrative courts exactly because of the role that it was given, that actually protects judicially the citizens against the discretion of the administrative bodies, that it was given the role to control these administrative acts judicially. So, for example, Croatia had the case in which the legislators suspended all cases, pending cases, which were pending before the administrative court and concerned the war veterans' rights. And the Constitutional Court got the initiative actually to abolish this law, and the Constitutional Court actually did it, but it made a large critics toward administrative courts, saying actually that the administrative court failed in recognizing its role in democratic society and within division of powers. Why? Because administrative courts, as soon as they got this law on, as soon as this law was enacted, they suspended all these acts and cases. So they really didn't care what was going on. and the issue actually whether the legislator can interfere into the pending cases that were going on before the administrative court concerned the principle of separation of powers. So how the application looks in the case of displaced persons and refugees. So as you can see from this body of legislation, most of these rights stemming from these laws that I showed you actually are the legal rights. They were expression of legal policy of a country to deal with consequences related to displaced persons, to the war. And of course, they were expression of the principle of the social state. So, but in context of constitutional rights, they might relate it upon issues like right to home, right to private life, right to property, or right to fair trial, depending how the administrative court approached to the certain administrative acts. So when reviewing whether a legal right is affected by certain constitutional right, the Constitution offers a tool which are mostly the principle of proportionality and the rule of law principle, whose elements actually I mentioned previously, and actually I also saw that Ukrainian constitution says that the judges are governed by the rule of law. So how does this look in practice? Now I would like somebody to return the last slide, if possible. Not possible. Further on, okay. Okay, so no, return one more. Return one more, please. Just one back, so another one. So forward. No, forward. You have 2 slides with decision. One forward, please. There it is. So what happened? Again, I relate to the Convalidation Act, which I think will be a rather interesting act in a close future to Ukraine because of the situation, political situation that you are having now. We had problematic issues related actually how to convalidate the rights of the people that lived in occupied territories and had to continue their lives on the other parts of Croatia, and actually to reconcile the time that was spent on the occupied territories. So what happened? The person wanted to convalidate the working experience, and this was not possible because he was denied this because the administrative bodies said actually that he was not. It was a male citizen. He was not actually recorded within the records, official records, and that also it had to do something that he worked for the police at that time, etc., etc. So he was denied, and actually he thought that he was discriminated, and that from the very beginning, actually, they did not take into account the proofs that were given in order to prove that he worked really over there and that his status could be convalidated. So next slide, please.
Пані Славіце, я перепрошую, що втручаюсь.
I really apologize, Ms. Bonish. We have only 10 minutes for each presentation. I can give you just 4, maybe 5 minutes for
this is okay. I'm finished. I'm finished. This is the last one. So I just wanted to say that the Constitutional Court actually, this part with bold says that that inequality was not reviewed from the aspect of prohibition of discrimination, but from the inequality within the Article 21(9), which says actually the right to fair trial. And actually the Constitutional Court realized that the procedural rules of the administrative procedure say that the proofs are possible for the sake of the principle of a material truth. And in that regard, they had to take care about this aspect in order to enable the protection to the citizen, and the administrative court failed in that regard. So I will finish this by this slide. I had something else to say, but I hope that in the discussion, the issues, the questions could be posed. Thank you very much.
Пані Славіце, надзвичайно цікаво. Ми ще будемо вивчати.
It's indeed very interesting presentation. Certainly need to examine it very carefully because, let me be honest, your points are very relevant for us as of today, and I will just say a couple of words. You mentioned the procedure, and the administrative court actually took into account the basic principles of the procedure in recently the parliament passed a law on administrative procedure which had been prepared for 20 years. And then through the Article 2, the Court of Administrative Justice, the Administrative Court applied these principles which generate main criteria put into foundation of this law on administrative procedure, thus limiting the discretion powers of administrative authority. So this is very relevant to us. Believe me, we continuously discuss this doctrine. And now we have the last participant, Ms. Hanna Christova. She is the project manager of Council of Europe project on the internally displaced person. She is a PG legal sciences. She will talk about transitional justice, and you are kindly requested to really fit into the framework and timing that was offered to you. Thank you very much. Please put your mic on. We cannot hear you.
Включіть мікрофон свій. Так, так, прошу.
Я перепрошую, але це техніка вже, да.
I'm sorry, that's no, the equipment probably is tired. So I'll try to compensate this delay on my side. And first of all, we are very thankful to the Supreme Court, Constitutional Court of Ukraine for your participation, for your initiative to undertake this event and for the discussion, which certainly raises many issues, but at the same time offers some ways of solution. I will use this opportunity for the floor in the end of this event. I'd like to maybe actualize the problems that are becoming relevant now and probably will remain relevant for Ukraine for probably many years in the future, because those countries which suffered from the armed conflict after the World War II, I'm talking not just about African Asian countries, but about European countries subject to European law and order system, and that was in the competence of the Court of Human Rights. Know that the transitional justice may take years, and this is the reality that you just cannot disregard. I can only outline some problems to share my vision of some concepts which are now beginning to be perceived as specific legal terminology, which certainly will have to be used by judicial system of Ukraine in the nearest future. And probably the point that I will start with, and I will finish with the same point within 7 minutes, is this. Today, during our discussions, it was stated a number of times that in absence of very specialized and concrete provisions of the constitutions which exist, but not are regular practices, of course, for constitution, because most of constitutional provisions are general and abstract. Then the principle of the supremacy of law declared in the Article 8 of the Constitution of Ukraine, we can actually find some solutions. And this is the principle through which we can view or examine the point of constitutionality or non-constitutionality of specific laws or other legal acts. Somebody has to put the mic off. So the key point is this. Will the principle of the rule of law be applicable in case if transitional justice is taking place in transitional periods? Then this is the question that needs to be answered, first of all, from the point of view of international standards. Yes, we hear some other sounds. There are some obstacles, but I hope that you have heard. I will repeat it once again. The principle of the rule of law, is it applicable to transitional periods and transitional justice within the scope in which it applies at normal peace time? And the answer is suggested by the international standards that I'd like to mention very quickly. Another point consists in that gradually the Ukrainian terminology uses more and more the notion of transitional justice. It has already been used in the current legislation of Ukraine, specifically within the context of the legislation on reintegration of Crimea. So respectively, this is the terminology which is becoming more and more relevant. Certainly soon it will be used in a specific law because the respective draft has already been submitted to the parliament under the name of principles of national policy during the transitional period. So if we systemize our approaches, probably the United Nations in particular developed this notion of transitional justice and prepared very useful report on the rule of law in conflict-affected societies. And this specific report states that the main point of transitional justice is to restore in full the rule of law. Now I can see that I cannot page my slides. Of course, that will make my life a bit more complicated, so I can. So the key terms with respect to which there are agreements, as suggested by UN and supported by respective Council of Europe resolutions, that's the notion of the justice, in the wide notion of the rule of law in the conflict affect the society is to be understood when all entities, including the state itself, obey to the laws that are equally applied, ensured with specific judicial protection, and meet the international norms and standards of the human rights. I mean, we're getting back to all these notions that we've discussed during the previous sessions, and the rule of law will demand compliance with equality before the law, responsibility before the law, fair application of the law, distribution of powers, involvement in decision-making, procedural and legal transparency. So the basis of this understanding of the rule of law in post-conflict and conflict societies will be placed in the statute of the UN, European Convention of Human Rights, and also pillars of international legal system, international law of human rights, international humanitarian law, international criminal law, international law on the rights of refugees, meaning that all these tools shall be used until the time of the respective state approves its relevant to the respective legislation. So this justice covers all set of mechanisms by which the society tries to reach agreement with respect to number of violations and breaches committed before and with regard to respective punishment of the involved individuals. As you can see, it also
Саме індивідуальні судові переслідування
carries various levels of international participation, as well as reparation, as search for truth, respective administrative decisions, etc. So that is why the comprehensive set of this draft law suggests using the term transitional justice. Well, in Ukrainian there are two different words, because actually here we're talking about namely the by recommendation of judicial instances, the authors suggest using the English, the Latin term justice rather than Ukrainian term, which also is justice in English. So here are some elements of the transitional justice. You will have these materials available. I'd like only to draw your attention to the fact that they include elements related to the rule of law in the criminal proceedings and the administrative cases. In particular, a necessary element of transitional justice is prosecution of the individuals who committed serious breaches of international law, international humanitarian law. It's rather within the framework of criminal justice, and also these are matters related to compensation of damages to the victims of such actions, supporting them with respective remedies. Another aspect is establishing the truth, institutional reforms, and internal governmental consultations. And finally, the legal lengths of transitional period often characterized with some discriminatory elements that they may contain some one-sided interpretation of the past. So the suggestion is to use very interesting term, which is transitional constitutionalism. So here the task of the constitutional of transitional constitutionalism consists in that, in spite of the challenges to the basic constitutional principles, such principles need to be ensured as the main task, and the respect for the rule of law again is the main task, which needs to be kept in mind during this transitional period. Yes, I really apologize, Hannah. We have very little time to finish our event. Then I think I only should finalize and tell that there are different interesting approaches on how within the system states have interpreted differently the principle of the rule of law, and respectively finding different solutions, the same issues like, say, period of limitations with respect to the crimes committed during the conflict, and many other points like this. For instance, if you look at Czech Republic and Slovak Republic, they had different approaches, and Eastern Germany had their approach to this. And talking about the position of the Venice Commission and their opinion with regard to the law transitional period, it was published on their website, and we'll be happy to add this opinion to this presentation, where the central focus should be made on the recommendations that should prevent the Ukrainian transitional legislation protected from the violation of main principles of the international law, while the specific examples with regard to illustration, prohibition of any symbols, use of international law terms, all these are given here in the presentation. And unfortunately, I cannot read them loud, but you'll find all necessary criteria and principles in the presentation. Thank you very much. This has been a large challenge for all of us to keep the time frame.
Thank you for your presentation. We will refer to your presentations at a later time. We have only 10 minutes remaining, and there's one question raised by our presenters, and I'm urging our international experts to address this question. I'm addressing Slavica Banic about the clear criteria for the court making the decision that the law is unconstitutional or inconsistent. Could you give us some criteria, like the quality of these legal acts? Share your vision. Give us some advice, some recommendations that you could give to the judges when they consider a legal act for constitutionality in a particular legal dispute. So what, perhaps some guidelines or some European standards that we have overlooked and have not mentioned today during the discussion, but if you could only take a few minutes, please.
Thank you very much. We always actually firstly refer to the existing European Court on Human Rights practice, as well as of the German Constitutional Court practice. But as regard to the quality of laws, more and more we receive really very good initiatives, which actually clarify us on already existing individual situations that might be problematic, and that they actually advise us to this. But for example, we had the case regarding to the quality of law. We also faced the legal gaps which were existing and which were actually such situations were violating the individual constitutional right. For example, we had the case of the transsexual, transgender person who changed actually the sex, and the man became a woman or opposite, I don't remember anymore, but actually could not apply to the documents because the government did not enact the bylaw, the lower act. So law allowed it, but the bylaw was not introduced, and actually all the bodies were stuck and could not proceed with this request because they were missing this, and they interrupted the administrative dispute, and the person waited for years to acquire these rights and couldn't do this. So the person came to the Constitutional Court, and we actually abolished all the administrative acts. We said actually that because of gaps in the legal, in relation to legislation, the person could not the person could not enjoy the individual rights, and that the country actually did not only have negative obligations not to encroach the constitutional rights, but also positive obligations, and to establish the legislation as soon as possible that these rights are effective, that these rights are actually not illusionary. So, for example, the quality of law, for example, is always very much depending on review whether it provides the problem with legal certainty. So legal certainty becomes actually the most common problem in reviewing the legal acts, so the laws with regard to certain issues. We also have the problem with hidden retroactivity. And therefore, we also oblige the legislator that as soon as they actually establish retroactive norm, because by the constitution of Croatia, it is possible that one norm is retroactive, but for a good cause, with explanation. And what had happened, you know, that actually the retroactive norms were established, but never explained. So it came to a total legal uncertainty by different bodies, because both administrative bodies and the courts interpreted these retroactive provisions differently. So it introduced a large portion of legal uncertainty in this field. But the most, I would say that the most frequent approach to the issue, whether with regard to the quality of law, is that we use principle of proportionality in measuring actually when certain rights are established, enacted, whether they are of such nature that they are necessary in the democratic society, that certain obligation prevails in relation to the right. So we really, I must say, Mr. Broker is here, that we use a lot of the experiences of the German Constitutional Court, Austrian Constitutional Court, and of course, very much the European Court of Human Rights. But sometimes it's not possible because we have our internal situation, we have our social, we have our society, which is culturally different. And sometimes we have to actually see how it functions in Croatia, and we look at the predictions, how the certain law is applied in the practice. And therefore the initiatives are sometimes very well in revealing the problematic parts of the law. So therefore, for example, we had the case before the administrative court, which I wanted to tell you. I'm sorry, I'm a little bit long with this. The applicant actually was alleging that his right to private. So the applicant. What was it? I couldn't. The applicant was disputing that his right.
Заявник, I'm asking you to take a minute, if we may, because we really have to wrap up. So a minute to conclude, please. Just tell us the case in brief, a minute.
No, the case concerned that the applicant actually called on his constitutional rights all the way in the procedure, but the administrative court did not ignore it. So this is the problem with Croatia very much, that the courts ignore the reference to the constitutional rights. And the Constitutional Court abolished the decision saying, because you did not refer to his allegations regarding the constitutional right, you violated his right to appeal. So this was the case. So this is what I want to tell you.
Дуже дякую. Дякую, Славіця.
Thank you very much, Slavica. Mr. Broker, you've been referred to. So, and please take a minute if you will.
Ja, ich werde es kurz machen, aber Sie kommen zu den ganz wesentlichen Fragen der Verfassungsinterpretation. Eine Frage, der wir uns alle stellen müssen, ob Verwaltungsrichter oder Verfassungsrichter.
I'll be very brief. Now we've touched the most important matter, the interpretation of the Constitution that any administrative court judge has to deal with, and not judges of the Constitutional
Court. Des
Court.
Verfassungsrichters entscheidet sich nicht wesentlich von der des Verwaltungsrichters in diesem Moment, sondern wir nehmen das Handwerkszeug, das wir als Juristen gelernt haben. Die alten Interpretationsgrundsätze, die wir schon von Savigny kennen, von den alten Preußen.
And here we need to underscore that the administrative court judges are not very different from the judges of the Constitutional Court when they do the interpretation. it starts with the very basics of the legal studies
So haben wir
that we've
die
been trained in.
üblichen 4 Kanones, den Wortlaut, den Sinn und Zweck, die Systematik der Norm und den historischen Kontext, die Entwicklung der Norm.
And in here we have 4 canons that we resort to: the content of the norm, the sense that the lawmakers vested in it, the consistency, and the 4th reason.
Und jetzt kommt bei uns hinzu, dass wir sehr unterscheiden müssen als Verwaltungsrechtler, als Verwaltungsrichter. Haben wir es mit einem Parlamentsgesetz zu tun oder haben wir es mit einfachem Recht, mit einer Verordnung zu tun? Die dürfen wir selbst verwerfen als verfassungswidrig.
І тут треба ще наголосити на тому,
And another thing we should say that the German courts have an additional feature that they can find certain legal acts unconstitutional if they are substantive laws, informal laws made by the executive power. This is a special feature of Germany. Only special laws have to be referred to the Constitutional Court.
Und das Bundesverfassungsgericht wegen Artikel 100 Grundgesetz verlangt von uns, dass wir detailliert begründen, unter umfassender Auswertung der Rechtsprechung des Bundesverfassungsgerichts, warum wir die Norm für verfassungswidrig halten. Wir müssen alle einschlägigen Entscheidungen berücksichtigen.
This submission of the administrative court to the constitutional court based on the fundamental law of Germany demands that the federal constitutional court judges give an in-depth reasoning why they believe the formal norm of the law be inconsistent with the Constitution and refer to the established case law of both administrative justice and of the Federal Constitutional Court.
Die Frage ist zum Beispiel unzulässig. Das Bundesverfassungsgericht sagt dann, die Frage könnt ihr alleine entscheiden. Eure Frage an uns ist unzulässig, wenn wir nicht genau begründen.
And if this reasoning, in the opinion of the Federal Constitutional Court, isn't sufficient, if the standards about the reasoning and the justifications are not met, then the Federal Constitutional Court will find the application ungrounded and rescind it.
Vielleicht noch 2 Sätze. Das Bundesverfassungsgericht hat vor 2 Tagen eine sehr interessante Entscheidung veröffentlicht dazu.
And 2 more sentences. 2 days ago, the Federal Constitutional Court published one of the decisions on the matter.
Es ging darum, dass Bürger bezahlen müssen, wenn an ihrem Haus die Straße neu gemacht wird.
This was a case that people had to pay certain contributions if the road was being repaired in front of their houses.
Weil sagt, ja, die Straße ist aber vor 25 Jahren gemacht worden und jetzt bekomme ich auf einmal eine Rechnung.
And the people who received the bill from the road services went to court, and it went up to the Federal Constitutional Court, but he said the road was built 55 years ago. Why do you have to pay for the repairs?
Und das ist eine Frage der Rechtsstaatlichkeit. Das Bundesverfassungsgericht hat gesagt, irgendwann muss ich sicher sein, dass der Staat nicht mehr auf mich zukommt mit so einer Forderung. Die Vorhersehbarkeit.
And the Federal Constitutional Court, when justifying its decision, made a reference that the citizen should be certain that the government will not keep billing him. And it's about the legal certainty and safety of the people
Aber das Interessante
in
ist
his
der Weg
relations
zu
with
der
the
Entscheidung.
state.
In unserem Gesetz hatten wir keine Verjährungsfrist, keine Obergrenze. In dem Gesetz stand nicht, dass nach 10 Jahren oder nach 20 Jahren Verjährung eintritt. Und das Verwaltungsgericht und das Oberverwaltungsgericht haben gesagt, das ist in Ordnung. Und dann hat das Bundesverwaltungsgericht die Frage dem Bundesverfassungsgericht vorgelegt. Und das Bundesverfassungsgericht hat gesagt, das Gesetz ist verfassungswidrig.
So why was the question raised? Because the first and second instance, administrative court and high administrative court ruled that the bills are all right, because the law does not make any provisions about the terms of limitations. You can still bill a person 20 years after the effect for the reconstruction or construction of the road, and the federal court abolished the two decisions and saying this is not all right with legal certainty about the relations between the person and the state, and the court
und diese Frage hat das
Bundesverwaltungsgericht
dem Bundesverfassungsgericht vorgelegt. Geschrieben hat die Entscheidung mein Freund Martin Steinkühler, den kennt Herr Smokowicz auch ganz gut.
And this reference to the federal Constitutional Court was made by the Judge Steinkühler, which is known by the Ukrainian counterparts, and particularly by Mr. Smokowicz. Thank you very much for your remarks. Thank you for your contribution. I will recap. These are open matters. We only started the discussion, and I hope during the next meeting we'll start by providing the summaries. I beg your pardon if I haven't given you a chance to say everything you wanted to say. We hopefully will still have an opportunity to meet again. I would like to urge you to raise from a legal discussion to a spiritual discussion. In conclusion, I would like to introduce to you Bishop Boris Hudyak. He is the president of the Ukrainian Catholic University, and I used to work for the Ukrainian Catholic University earlier, and I held the position of the professor in the School of Law of the university, where they trained both the bachelors and masters of law. And in this context, we brought in the bishop, asking him to give us some insight into some categories that underpin the principles of justice, the principles of goodness. I'm asking you to play the video.
To be a judge. I hope we will be able to implement this idea. To be a judge and to be a fair judge is not easy in any context. Human conflicts, they're hot. People's passions, people's anxieties, sometimes very negative emotions, which create very uncomfortable situation, confrontations. That's why I want to thank to all of you who are dedicated to this very difficult service. Every judge makes a judgment, and by making deliverance of judgment, he or she is not just solving a case, but emphasize the sense of fairness and trust to the judicial system. The main law of Ukraine, according to its preamble, the constitution was passed by the parliament on behalf of the Ukrainian people with recognition of responsibility before the God. It's very important. The responsibility before the God, before our conscience, current and future generations. The God is mentioned in this legal document is exclusively Ukrainian phenomenon, is not exclusively Ukrainian phenomenon. There are some similar references in constitutions of the United States, each state, Canada, Ireland, and many other states. The researchers say that it gives transcendental meaning to the fundamental document of the state. The categories which are traditionally perceived as merely legal are perceived inclusively through main postulates of the Catholic Church. Fairness, human rights, solidarity may become the point of support where for the purposes of decision making, the legal provisions are silent or contradictory. I'm very thankful to organizers of this conference and to all the lawyers who are not indifferent to human pain, who understand that we are all in front of the God. In front of you, you have the most important task for the Ukrainian society, building trust, solidarity, and the state based on law. Thank you very much, Vladika, for these guidelines. Esteemed participants, before I give the floor to the Mr. Smakovich, head of Cassation Court, with the Supreme Court, I want to thank all my colleagues, to our secretary, to all of you who made the presentations, who supported technically this event in these hard times of pandemics and complications related to some limitations of communications and traffic. I hope that this information has been helpful to clarify some points that we started discussing and continued discussion during our meeting. So I'm saying see you again, and I'm offering the concluding remarks for the floor, the individual who is a legend, leader of our administrative justice, Mr. Mikhail Smakovich. Please, the floor is yours. Dear friends, dear guests who join us online, I'm very thankful to all of you for the participation. The points, the issues related to administrative justice are very important in connection with the adoption of the legislation. Our administrative procedure, where many disputes will be solved by quasi-judicial authorities with respect to the aforementioned new forms of solving the public disputes. All these points are very important for us. It's a great pleasure for me to have heard many, I would say, novelties, sometimes just reminders about proper application of the constitutional principle of the rule of law as the regulator of non-regulated relations and as a mechanism, as a tool for interpretation of such cases. Very relevant issues have been raised, which where the resolution of them is very important for constitutional courts, administrative courts with respect to the resolutions of the plenary sessions of the courts. Is it a final instance decision, especially in the light of the latest constitutional court judgments? So is this a final authority, or is this a filter which may say no, and to what extent such resolutions of the plenary sessions are binding for the courts for the purposes of delivery of their judgments, which are binding, where some provisions are recognized or declared as non-constitutional. These are very important issues rising here. Then what do we mean by an act of a directive act that we need to apply? What if we cannot find them in the Constitution, even when we realize that certain provision counters the Constitution, still we cannot find the relevant act of directive fact to use it as regulator for purposes of conflict solving. So I want to thank all of you very much indeed. These problems are very relevant and topical for administrative courts, administrative jurisdiction. We try to look at them from many different sides and aspects. We gather here the best experts in the area. I mean, the best experts of Europe. So I want to thank, first of all, to our President of the Supreme Court, Ms. Valentina Danishevskaya, for her participation. My thanks to the Secretary of the Grand Chamber of the Supreme Court, Всеволод Knyazyev. My thanks to our permanent, I would say, partner, Dr. Lars Brooker, who is the President of Constitutional Judicial Chamber and High Administrative Court of and certainly we great friend. I still keep very good memories about Martin Steinfurter. And it's really nice to have such great friends in Germany who are great supporters of building the proper justice judicial system in Ukraine. Our thanks to Mr. Norkas, professor of university, Justice of European Court in Luxembourg, who used to be the president of the Lithuanian Administrative Supreme Court. He visited Ukraine many times. We worked together a lot. Thank you for sharing your experience. My thanks to Justices of Constitutional Court, Mr. Lemach, Mr. Gorodovenko. I've already had a chance to talk to them on the phone after their speeches. Thanks to them for sharing their views, their visions, their experience with regard to the right way for the administrative courts to solve the conflicts. And also for making sure that the administrative court do not outreach than trying to take over the powers of constitutional court. My thanks to Mr. Papashvili, former Minister of Justice, and thanks to former member of the European Commission, current member of Venice Commission, who has always been very active and responding to our request and invitation. Also, my thanks to Savica Banic, who has been participant in our events many times, for Deputy Chair of the European Commission through the law. My thanks to Hanna Christova, the project manager of the Ukrainian project, devoted to internally displaced persons. We apologize for not being able to listen to your full presentations, but I'm confident we'll have many other meetings with this respect, and I really appreciate your understanding of the principle of the rule of law, which can be used as a mechanism for the interpretation of the legislation. My thanks to the justices of Cassation Supreme Court who prepared very informative presentations, who have demonstrated that in fact of this varying views over the provisions within the competence of the administrative courts. We are trying to do our best in order to find decent solutions to support those who need our protection. I'm talking about citizens and legal entities of Ukraine. My thanks to Miroslava Bilak, Justice of Cassation Administrative Court with the Supreme Court, who has managed to organize this event just in a month for this very high level of organization. My thanks to Boris Hudzak, who actually responded to our request and presented his view with respect to a figure of a judge who is supposed to solve conflicts. Thanks to our interpreters who actually had quite a hard job to do today because the subject matters are important and confusing. Also, I'd like to apologize for maybe some speakers who sometimes maybe try to go too fast in their presentations. For some technical complications, my thanks to Gennady Ryzhkov, the citizen of Ukraine, who is employee of German Fund for International Cooperation, our partner, who has always been very helpful, including today in communications with Mr. Lars Broker, and the one who helped us with organization of this event. Thanks to European Union, the Council of Europe, to OSCE, to German Fund for International Cooperation, including the leader Stefan Kerferster for supporting preparation of this event. I'd like to assure everybody that the judges of Ukraine, including the judges, administrative judges of Ukraine, do everything they can to make sure that the protection of rights and freedoms of all Ukrainians be at the appropriate level. Believe me, this is the case now already, in spite of all the criticism that you may hear with regard to the judges. The judicial work needs to be assessed according to the judgments, and they're fair. So I wish all of you strong health, the best of luck to all of you. Thank you all very much.